by us and by our witnesses in direct pre-filed testimony. And so I register a concern and I think appropriately an objection. I would note finally that, as everyone is aware, the exhibit list was developed and exhibits were admitted. And the first substantive hearing in this proceeding was conducted at times when our clients had not been allowed to intervene and were not full parties in the proceeding. So yesterday's notice is certainly short notice as it relates to the residents.
Mr. Bucci, do you have any comment?
I have nothing further to add than was already commented.
Well, then, when I saw, let me make this ruling, which is when I initially saw Mr. Haverty's email, I recalled our discussion of exhibits during the pre-hearing conference last week, and I was prepared to say that what's good for the goose is good for the gander. But when I looked more carefully, I realized a couple of things. First of all, what the landscape plan actually is 14 sheets, and much of it is already in evidence as Exhibit 3, the what you refer to, Mr. Deutsch, from the utilities plans and so on, are already in evidence, and what's added to it is a landscape plan. As I say, both of the interveners, even though they were not granted full intervention early in the hearing, were participating as interested persons, and as a result have seen all the pleadings, and these exhibits have been part of the record for quite a while. And finally, I guess I would point out that in part of the we're an administrative body. We're much looser, considerably looser, somewhat looser than a court would be on these sorts of things. And in particular, we're very concerned that when we make a decision, or whichever direction it goes, that be very clear. There'll be a very clear record in case there needs to be further review. And these plans, in particular, are not, are not, in a sense, they're not argumentative documents. They're not opinions by an expert or anything like that. They are the basic documents that establish what the proposal that is before the committee is. And on that basis, I'm going to admit both of them into evidence. So the 14-page landscape plan, which says at the top, SCN development, and then it indicates that the landscape architect is Hearn Landscaping Design Studio, and it's dated March 6, 2020. Will be admitted as Exhibit 71. And then what we'll call the land bank and banked, for the stenographer, that's land banked, BANKED, parking plan, will be admitted as Exhibit 72. It can be listed as, in parentheses, what it says on the plan is layout plan by Bracken Engineering, revise parking 6/20. All right, with that, is there anything else that's preliminary before we start talking about we're not quite sure who we're going to start with before we actually lay down the order? With that, is there anything else that's preliminary before we start?
Yes, Mr. Lowy, I had one other housekeeping matter. Like Attorney Haverty, yesterday I was going through to make sure everything in the record was clear, and I noticed that one of my witnesses, Dr. Boyes, her pre-filed testimony, which is Exhibit 60, there's a blank on page 3 in paragraph 12. It's a citation. It was a reference to Exhibit 25, which is the open space plan. And the version she signed and we submitted didn't have the page reference in her testimony. And I just wanted to provide it. If you like, I'm happy to put a corrected page up into the SharePoint. But The citation is to page 135. So that's on page 3 of Exhibit 60, and the third line down refers to Exhibit 25 at page, and it should read 135.
Thank you very much. I'll leave it to Ms. Loftus and Ms. Barrows to determine whether it's easy technologically to substitute that page. If you'll put in the SharePoint, I'd appreciate it, and say we may or may not do that. I think everybody can keep track of it. It's helpful to have filled in that blank, and if they can do it in a minute, maybe we'll substitute it. But one way or the other, it's in the record, and I thank you.
And just to clarify, that was page 135, Dennis?
Yes, correct.
Thank you.
All right. What we talked about last week was we weren't sure whether Mr. Gray would testify or not. And since he's a town employee, we always want to give them some special consideration since they have lots of other work to do. And he would testify first, but he may or may not be needed to testify. Can you tell me what the decision is?
Yes, thank you, Mr. Lowy. As I communicated to council with copy to others yesterday, the resident interveners have decided not to call Mr. Gray as a witness in cross-examination, while nonetheless necessarily reserving our right to potentially call him as a rebuttal witness if circumstances warrant, and if so, would do so on a basis that is feasible given his schedule and the town's needs. And that was acknowledged by others, including, I think, Mr. Pucci, with whom I'd been communicating in prior days about matters related to Mr. Gray and the relevant evidence.
Thank you very much, Mr. Deutsch. Sounds like a very reasonable approach. You certainly can reserve your rights, and I'm sure Mr. Gray appreciates not having to be called unless it's absolutely necessary. So with that, I believe what we decided we'll do today is hear first cross-examination from Mr. Feely, and then cross-examination of Mr. Madden. And then unless somebody tells me differently, I think the way we'd approach it, since we have 4 parties involved here, is with both of them. We would, let's just deal with Mr. Feely right now. We call Mr. Feely. His written testimony is already in the record. He would be cross-examined first by Mr. Murphy for the Nantucket Land Council, and then by either Mr. Deutsch or Mr. DeRensis for the residents, and then by Mr. Pucci for the board, and then finally redirect by Mr. Haverty if necessary. Does that make sense to everyone?
Yes.
Yes.
Good. Thank you. Can we I'm trying to see Mr. Feely. Can you hear us here? I see you on the screen, so it looks like we're ready to go.
I can. Good morning, Presiding Officer Lowy.
And I think we may have been good. Let's hold for a minute from Ms. Starr.
Yes. I'm sorry. Who was doing the first cross-examination?
The first cross-examination will be Mr. Murphy.
Okay. If you could just bear with me while I remove someone and pin Mr. Feely.
Yes.
I do not have Mr. Feely at all on the screen.
I have him front and center. Mr. Feely, why don't you just say hello? That may help get you.
Okay, I'm all set right now. Yep. So I have Mr. Murphy, Mr. Feely, the presiding officer. I have Mr. Pucci. I do not have anyone else on the screen. So if I could just ask if anybody makes a comment or an objection or speaks up, if they could just identify themselves, because I will not know who's speaking, if that's okay.
That sounds perfect.
Thank you.
And if there's a problem, just interrupt us.
Thank you.
So, Mr. Hearing Officer, I think it would make sense, since I'm really probably the only one that will be making any objections to any questions asked by Attorney Murphy, that I be pinned so that I don't have to keep identifying myself.
Good point.
And who was it that said that?
I'm sorry, this is Attorney Haverty.
Okay. Okay, bear with me again then. Okay, thank you. Thank you.
You're welcome. Mr. Feely, welcome. You may have been under oath before, but let me put you under oath again, just as a reminder. Would you please raise your right hand? Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you very much. Mr. Murphy.
Thank you. Good morning, Mr. Feely. How are you?
I'm well. Good morning, Mr. Murphy.
Could you please give us your name and address for the record?
Sure. My name's James Feely, and my address is 5 Evergreen Way, Nantucket.
Is that your home address, sir?
Yes,
And do you understand that you're here today in a representative capacity?
I do.
And what entity do you represent?
I represent the developer, Surfside Crossing. I represent as a witness. I'm representing. Well, I'll just leave it as the developer. I mean, obviously, I've submitted testimony with expertise in construction and real estate.
Yes, and I'll just say right up front that I'm going to assume everyone is familiar with your prior testimony, which is Exhibit 31. And I'm going to go really quick through the preliminaries so that we don't have to repeat them from last year. So Surfside Crossing, that's an LLC, right?
Yes.
And you're a member of the LLC?
Yes.
Are there other members?
Yes.
Who are they?
Rugged Scott LLC.
Okay. Now, according to what I see on the Secretary of State's website, the manager of Surfside Crossing LLC is a different entity called Surfside Crossing Partners LLC. Is that right?
Yes.
And are you a member of that LLC?
Yes.
And are there other members?
Mr. Hearing Officer, I'm going to object here. I'm not sure how this line of questioning is relevant.
These are standard questions for anyone testifying in a representative capacity. I only have, there are 3 LLCs. I'm going to establish what they are and what Mr. Feely's role is in each.
Objections overruled.
Thank you. Mr. Feely, do you remember the question?
Yes, but would you repeat it, please?
So we were talking about Surfside Crossing Partners LLC, which you're a member of. Who are the other members, if any?
Okay, so 3 through 9 Surfside South Shore Road LLC, Rugged Scott LLC, and Surfside Crossing Partners LLC. Is that right?
Okay. I believe that's right. Thank you. Now, the last one you just referenced, 3 through 9 South Shore Road LLC.
Yeah.
Are you a member of that one?
Yes.
And in fact, you're the manager of that one, right?
Yes.
In your own name.
Correct.
Okay. Are there other members of 3 through 9 South Shore Road LLC?
No.
Okay. Can I just ask you, is this a typical structure for the development trade, or is this something particular for 40Bs or just this project?
I'll just speak to this project. That's the way we chose to set it up.
Okay, but you do other developments on Nantucket, right?
I do.
Do you do them under any other name than the ones we've been discussing so far?
Yes.
And what's that name?
Other developments that I've been involved in?
Yes.
Wesco.
Is it called Castle and Cottage? Is that something that you're affiliated with?
Cottage and Castle is a construction company that I own. That's a corporation.
Okay. Are there others?
Are there other entities which I have been a part of as a development project? Is that the question?
Associated with this project?
No.
Okay. Can I just ask, among these different entities, how were you chosen to be the one to testify in this matter?
Because I have expertise in the construction element and in the real estate element. So it was under that testimony that it made sense for me to be a part of it.
Okay. And under this structure, are you the one calling the shots for this project?
Well, it's a partnership, so.
So you have other partners that participate in the decision making?
Yes, Josh Posner, Rugged Scott LLC.
Okay. Well, thank you for that. Why don't we, if you could just briefly tell us your educational background, professional experience.
Sure. My education is I have a BA from Boston College. My professional background is that I'm a licensed construction supervisor. I'm a licensed real estate broker. And my professional experience is as a construction company owner and developer for the past 23 years.
And you're you mentioned a construction supervisor. You hold that license?
Yes.
Is that right?
Yes.
And what was the other license you hold? A real estate agent?
Real estate broker. Yes.
Okay. And are those licenses in good standing currently?
As far as I know.
Okay. Any relevant job history prior to your development work on Nantucket?
Prior to my development work on Nantucket, out of college, I worked on a ski mountain in Lake Tahoe. And after that, I moved back to Nantucket. And for a period of time, I worked in retail downtown for 3 years. And then I built my first home, and that's what got me into development and construction. And that's where I started Cottage and Castle.
Okay, great. Thank you. How about non-professional, like civic activities or community involvement on Nantucket?
On Nantucket, I am a part of the Nantucket Hunting Association, and I sit on their range committee. I have been on the board of the Nantucket Children's House to Montessori Preschool. I have served on the Nantucket Coastal Management Work Group, and I think that sums it up for Nantucket.
Okay. In connection with you mentioned the coastal management work group.
Yes.
Are you familiar with any of the Nantucket planning documents? There's a master plan, an open space plan, coastal resiliency plan.
Yeah, yes, I am familiar with these documents and their existence. And
are they something you work with regularly in your professional development experience?
not regularly, no.
Okay. Let me just ask very briefly, if you've ever given testimony before in any kind of deposition or lawsuit.
Yes.
And without getting into the subject, could you just tell me basically what the matter was, when it was, and
Sure. It was this hearing roughly 2 years ago, and I've been deposed on insurance-related matters in construction.
okay. I'm going to ask specifically because I think it was a development that you worked on. Did you work on the Beach Plum Village project?
As the contractor, yes.
And is that also called Rugged Scott? That's the same one?
The same one, what?
The same development project?
Same as what?
I'm sorry. Are Beach Plum Village and Rugged Scott, do they refer to the same development project?
No, I believe Rugged Scott is the owner entity behind the Beach Plum Village project.
Okay. So, but they refer to the same houses, even though they're different entities and they serve a different function, right?
Yes, they're not the same thing.
Okay, I was confused. I thought there might be two different 40Bs on Nantucket, one called Rugged Scott, one called Beach Plum Village. It's the same one, isn't it?
No, Beach Plum Village is a 40B. Rugged Scott is not a 40B.
Okay. Well, maybe my question is about a different project, but did you have one of your subs fall off a scaffold at the Beach Plum Village job site when you were the GC?
I did have a subcontractor fall from staging. Yes, a subcontractor.
Is that one of the matters in which you testified previously?
Mr. Hearing Officer, again, I'm going to object to this line of questioning. I don't see how it's relevant.
Objection sustained. Objection sustained.
Okay, well, let me just ask more generally. Are you familiar with how to testify in a proceeding where your words are being taken down by a stenographer?
Yes.
Okay, so we don't have to go over the ground rules about nonverbal cues and using words to answer as opposed to gestures and that sort of thing.
Correct.
Okay, good. Let me ask, you mentioned that you were the general contractor on the Beach Plum Village project. Is that right?
Not for the entire project, but I came in after a period of time. After I came in, I think it was 2011. So they had already built 10 homes at that point.
And who did you replace?
It's a good question. I think they shut the project down for a period of time during the recession. And when he was ready to bring it back online, his previous builder, I'm not sure that entity still existed. And I'm sorry, I don't know the exact name of that company.
That's okay. It sounds like you saved the day there. Who was the developer of the Beach Plum Village project?
Josh Posner.
And was he operating as Rugged Scott, the entity?
I believe so.
Okay. And was there anybody else that's on the same team for Surfside that was also involved in the Beach Plum Village other than you and Mr. Posner?
Not that I'm aware.
Well, let me ask specifically, was Mr. Madden of LEC, who's here today, and I can ask him, but was he involved in that one as well?
Excuse me, Mr. Murphy. There hasn't been an objection, but you're going pretty far afield here, particularly with regard to
Mr. Hearing Officer, I'm sorry to interrupt. I was about to make the leap to Surfside Crossing, and my understanding, and I could have the name wrong, is that Mr. Feely has been involved in exactly one other 40B, and I was just taking a minute to make the point that it's the same team in both cases.
Well, you've taken quite a longer than a minute to make that point, and I'm not even sure that his experience is pretty clear on the record. What I want to get to, while it's still daylight, is the question: is the factual issues that concern your clients. Continue, but please keep it short.
Okay, thanks, Mr. Feely. Just a few questions about Beach Plum Village. Is that a 40B?
Yes.
And were you involved in that project?
As the contractor, yes.
Okay. Do you know, does it have any open space?
Yes.
How much?
I don't know.
Do you know where it is on the site?
I know that there's buffer areas, and I know that there's a park central to the site.
Okay. And do you know why those areas were included in Beach Plum Village?
Objection, Mr. Hearing Officer.
Only if he knows.
We haven't established that Mr. Feely had any involvement in that permitting process.
Well, further, Mr. Murphy, I don't see the relevance of why open space may have been included in some other development. We're concerned with this development, and I'm going to sustain the objection.
Okay. Mr. Feely, without reference to Beach Plum Village, does the park and open space area generally in a development serve as an amenity to the residents who live there?
Sometimes, yeah. Partially, yes.
Can you give any examples?
Well, I would think that the park would be qualified as an amenity.
Okay. Let's turn to the current project, Surfside Crossing. You're the developer this time, not just the GC, right?
Correct.
And do you have an equity stake in the project now?
I'm a part owner.
Okay. And will your construction company also be the general contractor for this project?
Yes.
Okay. Is it the case that the lack of open space at Surfside Crossing was a concern that was discussed at the ZBA during the public hearing?
Open space was discussed, yes.
And do you remember what the concern was?
Are you suggesting there was one concern, or? I mean,
well, if there were multiple, just tell me what they were if you remember.
what was discussed is the setbacks and the setback sizes, both of the lots, and the amount of usable green space as well.
Okay. Does the current plan for Surfside Crossing have a clubhouse?
We call it a community building.
Okay. And is that where the pool and the gym and the basketball court and those features are on the latest set of plans?
So there's the community building is in one location, and the pool is proximate to that building. And what were the other?
Well, I thought I saw a basketball court. It's all kind of in the middle of the site. Is that right?
Correct.
Okay. Now, according to your pre-filed testimony, the cost of constructing the clubhouse is almost $3.2 million. Is that right?
It sounds right.
Okay. For reference, that's paragraph 101. If you were to eliminate the community building with the pool and the clubhouse, would you save that $3.2 million if you didn't have to build it?
If I didn't have to spend that money, correct? Yes.
And could that area instead be used for open space as an amenity for the residents, just like at Beach Plum Village and other projects?
It could be.
Is that something that you considered at any point during this process?
Not having a community building or a pool or a tenant or a basketball court?
No, about whether to do open space as opposed to a community building or some other amenity.
Well, we did do open space, but we didn't consider not having a community building now.
And just like a park, a community building is an amenity for the residents, right?
Yes.
Okay. Are you aware that the ZBA imposed a condition that you hire an environmental monitor?
Yes.
And I believe you testified previously that the cost of that would be $50,000. Does that sound right to you?
Yes.
That's paragraphs 30 and 148 of the PFT for the record. So if you were to eliminate the clubhouse, wouldn't you have enough money now to hire an environmental monitor?
I hadn't thought of it as an either or.
Well, could you do both?
Are we looking at these things in a vacuum?
No, I didn't mean to suggest that. My simple point is that you could have some open space on the project where the clubhouse and the pool and the community building are, and you could save money. In fact, by my calculation, you could hire 64 environmental monitors for the money you'd save on the clubhouse. That was a statement.
Yes, Mr. Chairman.
I meant to ask a
question there.
How much does the gym equipment cost for the community building?
That's in the, is that in the budget? The gym is a specific line item. I think it is. Maybe we should.
The gym equipment. Well, I'll just, if I told you it's $50,000, paragraph 100, does that sound about right to you?
Yes.
So the environmental monitor is the same cost as the gym equipment for your community building. Is that right?
Roughly, yes.
Okay. Let me, if I could, ask a few questions about another 40B called Sachem's Path. Are you familiar with that project?
Yes.
And did you have any role in that?
No.
Okay. Are you aware that there's, at least according to Mr. Madden, 37 units on 9.1 acres at Sachem's Path?
Yes.
And that's a density of just over 4 units an acre, give or take?
Thought it was 4.5, but okay.
Okay. And let me just ask, have you read any of the pre-filed testimony that was submitted on behalf of the Land Council witnesses, Ms. Molden, Ms. Boyes, Gonzalez, or Daly?
I did go through all that when it was submitted a while back.
Okay. So do you recall that at Sachem's Path, there's actually over an acre of protected open space on that 40B site?
I'll take your word for it.
Okay. I don't want to have you go through my witness's testimony. Let me just ask you, if there's an acre at Sachem's Path, they were able to do a 40B development at 4 or 4.5 units per acre density. How come you can't make those numbers work at the site next door at Surfside Crossing?
I wasn't part of the development team. I don't know. I'm not privy to what their expenses were, what they, who's a part of funding that project, where they got their, I can't answer that question.
Okay, fair enough. Are you aware that the Sachem's Path site is also subject to the same mapped priority habitat as your Surfside Crossing site?
No.
That's probably a better question from Mr. Madden. Let me ask you one more about Sachem's Path, if I could. What would be the ramifications to Surfside Crossing if you were required to preserve some open space like they did at Beach Plum Village and like they did at Sachem's Path?
Well, I think we have.
Objection, Mr. Hearing Officer. There's really no basis for this question. We don't know.
This goes.
We don't know what he's asking in terms of what the open space requirement would be. It's very open.
The objection is overruled, and if it's not specific enough, Mr. Field, for you to answer, you can say that. But the objection is overruled.
Okay. Well, I don't specifically know the particulars of the open space on those other two developments, but from what you have said here, and if Sachem's Path has 1 acre out of the 9.1, I think that we are talking about over 2 acres of open space as it relates to our buffer on 13.58 or 56 acres. So I would suggest that they are similar.
Well, they may be similar in that they both have a buffer, but Sachem's Path and Beach Plum Village, I think we've established, both have a park or an interior area of basically undisturbed habitat that's open space, whether it's forest or grassland. And my simple question is, if those two could do it on their sites, why can't Surfside?
Well, I'm not as familiar with Sachem's Path as I am with Beach Plum Village, but I'm not familiar with an undisturbed area at Beach Plum Village on the interior.
Well, there's a park, right? So that qualifies as open space.
But you said undisturbed.
No, yes, I did. I meant in reference to the Sachem's Path.
Okay, but you applied it to both.
Yeah, my apologies. I'll withdraw that. Let me ask you about the plan for site clearing at Surfside. You mentioned earlier that you've been doing development for over 20 years on Nantucket. Is that right?
Yes.
In your experience, has there ever been a site that's been clear cut over 12 acres anywhere else on the island for any other project?
Well, I don't know the specific sizes of some of the other projects that I've seen around the island, but I've certainly seen other projects of large scale where that was the case.
Which ones?
The Richmond Group's project on South Shore Road, on Old South Road, the town's police and fire department project on Fairgrounds Road. Again, I'm not intimately familiar with these projects, so I don't know, what the buffers may have been or not been, but they were very vast areas that were clear cut as it related to those projects. I think Mile Shop and Natchitoches probably both fall into there. I did a project very early on in Mile Shop, and I think that's like 360 units where it's clear cut.
Okay. I'm not going to get into all of those, but I will certainly research the ones you told me. Can I just ask, does the comprehensive permit have any restriction from taking sand from the site, or gravel for that matter?
Not that I'm aware of.
Are you familiar with many other 40Bs? And in fact, before the committee, several cases have dealt with the issue of, housing sites being basically mined for sand and gravel. Are you aware of that?
No.
Is that the reason you want to clear cut the site? Is that so you can get at what's in the ground?
No.
Let me just switch gears a little bit, if I could. Did you accompany Dr. Boyes on her site visit a few months ago when she came to survey the Surfside Crossing site?
Yes.
And do you remember that day?
Yes.
You tell me what happened?
Sure. A representative from my firm and I met her at the site. We parked on the street. We agreed before we went on the site that this was intended to essentially replicate the site visit, which she missed. And that when we did the site visit, the kind of the ground rules were we're going to walk straight in all the way to the back and out, and that people weren't going to wander off the cleared area. And that's what, and she was agreeable to that. And that's what we did. We walked all the way into the clear cut, same as the site visit, and then walked all the way back out and stopped at any areas that she had, interest in.
And about how long was that time that you were on the site?
I would guess probably half an hour, maybe plus or minus.
And just so that I'm clear, this was back in January, right?
I think that's right.
Okay. Now, would you agree with what she said, which is of the 13-acre site, I really didn't even see a whole acre of it?
I would just say that she saw what everybody else did on the site visit, and it was my understanding that's what she was there to do.
And was your understanding informed by what you read from the hearing officer's ruling, or what you were told by somebody else?
I think that I had a conversation with my attorney about it, and it was his.
Okay, don't tell me about that. That's off limits what you and your attorney spoke about.
Okay, so I think there was an interpretation of the opinion or of the access that was granted, and that's how it was presented to me.
If it turns out that that interpretation were wrong, would you allow Dr. Boyes another opportunity so she could actually complete her field survey?
Mr. Murphy, I don't think this is relevant here at all. It's not been an objection, but we don't have time to go back over the terms on which Ms. Boyes may visit the site. If she or you or anyone else had a concern about that, I issued an order. You were certainly entitled, if you didn't feel that they were complying with the order, to ask about that. But at this point, we're concluding this hearing, and this is not a proper area for cross-examination of Mr. Feely.
Okay, I intended at the conclusion to take up this issue about the site visit, which we are going to move to have it rescheduled because it didn't occur as ordered based on my interpretation of the order. I'll finish with the witness, but that's where the questioning was going.
And Mr. Hearing Officer, the motion for the site visit was made because this particular witness had not been identified previously and was unable to have attended the original site visit. So the opportunity.
Both of you, we're not going to argue that right now. Let's do cross-examination of the witnesses on the issues that are before the committee, not on any procedural matter.
Okay. Mr. Feely, you mentioned earlier that in connection with your work for the town, including the coastal management group, you're familiar generally with the master plan and open space plan and planning documents. Is that right?
I said I was familiar of their existence. I'm not overly familiar with the plans themselves now.
Okay, well, in the interest of time, I will leave it to you. I have a series of questions about those documents. Are those things I should direct to you, or would you prefer I ask those to your expert, Mr. Matt?
I think you will be much more familiar with them than I am.
Okay, my only question then to you is whether any of those were consulted by you as part of the Surfside development process.
Directly, no. That's why we hired experts in each of the various areas, because they are inherently familiar with the regulatory documents and requirements.
And did you direct any of your experts to design the project, you know, to review those plans in their design of the project, or was it more that you were telling them to comply with state law?
I think that there was we picked a team that had familiarity with building and developing on Nantucket. So there was an expectation that there was a familiarity with the various local documents. And we had intended to be thoughtful in our design process to as many of those issues as possible. So I don't remember specifically pointing anybody to this document or that document, but we put together a team that we think has an inherent knowledge of building and developing on Nantucket.
Okay. You're known as a person of integrity on the island in your prior work. Hard work and accountability. Isn't that your tagline on your website?
I don't know that it's my tagline, but it's something that we certainly hold as high tenets. Yes.
If it turns out that the plans, whether it's the open space plan or the master plan, which was adopted by the planning board and at town meeting, that they require you to create open space at Surfside Crossing, will you do so?
We will go with what the regulations require us to go with.
Including the town plans that I just referenced?
No, including the 40B regulations.
Okay. I'm going to finish up in just a moment. I know people are probably ready for a break. Let me just ask, at some point you made a change while this matter was pending to all condos, right?
Yes.
Why was that?
Because for us, the condos are a housing product that we can build efficiently enough to price and put in a market that would be accessible to year-round Nantucketers at a market rate level. Doesn't exist on Nantucket otherwise.
Is short-term rental any part of your marketing calculus in that?
Could you be more specific in the question, please?
Well, you're aware that there's an issue on the island about short-term rentals, right?
Of course.
In fact, it's the subject of half a dozen articles on the town meeting warrant this year, last year. It must come up in your business, doesn't it?
Rentals is a very common thing on Nantucket, yes.
When I say short-term rental, you understand that I mean something less than 30 days, something that's put on Airbnb or VRBO or something like that, right?
I do.
Okay. So is it the case that a condo is more marketable for short-term rental than a single-family house?
I don't know.
Are you aware that at Sachem's Path, which is another 40B right next door, the Homeowners Association has a prohibition against short-term rentals? Did you know that?
No.
That's in the testimony of the women who live there that are witnesses in this matter. Would you be willing to put a similar prohibition in your homeowner's documents for this project?
Similar to a prohibition, probably not. But we have, and as part of the ZBA process, we did propose a restriction on a certain number of the market rate units that included keeping those units marketed within year-round homeownership. And in those instances, we did restrict these units to, as part of this proposal to the ZBA, these units would have been restricted to one rental up to 1 month. And so the reason for that was that we didn't want these units to be rental units from an investment standpoint, but we didn't feel that it was appropriate for us to prohibit a teacher, for example, from being able to get some income while she's on a summer trip to the Grand Canyons. And so we wanted to leave a narrow window that wouldn't change the nature or intent of the ownership and the use, but we didn't want to overburden the owners unfairly.
Okay, fair enough. So there will be some restriction as part of the homeowner's documents to one 30-day period. right?
So what I said was that we had proposed that to the ZBA at one point as part of a proposed restriction that we worked on in a focus group, which included some local housing folks. Ultimately, that was not embraced as part of their approval. As not
Mr. Murphy, how does this line of questioning relate to the issues on which the Nantucket Land Council was allowed to intervene?
Oh, I was, my initial question was about the project change from half condos and single family homes to all condos. So that was the nature of it. I can move on to my last topic and be just a couple of questions.
Thank
Mr.
you.
Hearing Officer, I do want to clarify the original proposal was 2/3 condominiums, 1/3 single family homes, not half and half.
It's in the record, but thank you. Go ahead, Mr. Murphy.
So, Mr. Feely, you and I have not met before today, but I know you by reputation are a good son of Nantucket. You're civic minded. You've built many people wonderful homes. And I think you're an asset to the community. You know, there's been real struggle over this project. And my question to you is that if there's an opportunity to resolve these issues in a way that gets you to what I understand your end goal is to provide real affordable housing to year-round residents who live on Nantucket, would you take it?
I would engage in a conversation, absolutely. I mean, I can't answer what I would and wouldn't take without any details whatsoever, but.
Well, hopefully that process can happen. And thank you very much for your time today. Is there anything I asked that you want to amend or clarify?
No,
Before we let it redirect, Mr. Murphy. As you suggested, it's probably good to take a quick break. I didn't say anything in the beginning about our schedule, but what we'll do is we will run through till noon or approximately. If we have to go a couple minutes longer to finish something up, we can do that. But we'll generally go 10 to 12, 1 to 3. And I'll try to take a 5-minute break in the middle like this. So let's do that right now. And then we'll come back and hear further cross-examination. So I have 11:08. The nice thing about these remote things is we can look at our computers and stay on time. So I'd like people back at 11:13 and we'll continue. Thank you.
Thank you.
Thank you.
Mr. Haverty, Mr. Pucci, you're both always very prompt. Thank you.
Welcome.
I'm going to ask everybody when they come back from lunch if they could possibly come back 5 minutes earlier so I can get some information, spellings, and other things that I might need, if that's okay with everybody.
Fine with me.
Thank you.
In fact, Ms. Starbucks, might actually be better is when we take a break for lunch is to ask people to stay on for a couple of minutes and let you do that. And, you know, when you're done with somebody, you can excuse them and they can go get their lunch, and then we can just start right up at 1 when we're done.
That's fine. Yep, that's fine. Thank you. Could I ask who's doing the next examination?
Well, it's either Mr. Deutsch or Mr. Durensis. I think it may be Mr. Durensis.
Okay.
While we're waiting, you want to get some information right now? Or was that too confusing from somebody that's here?
Well, it takes me a minute to scan through, and I don't want to keep anybody held up.
All right, Mr. Deutsch, Mr. Durensis. Mr. Deutsch, which of you is doing the cross-examination here?
Thank you, Mr. Durant. Attorney Durant is going to be asking you questions, Mr. Freeman.
Okay.
Thank you. Mr. Feely, my name is Paul Durensis, and I'm here to represent a number of the neighbors to the Surfside Crossing project.
Good morning, Mr. Durensis.
They have not had a chance to see the details of the new project, so I'm going to ask you a number of questions about that so that people can understand that project and what's involved. So ask your indulgence.
You ought to ask my indulgence too, Mr. Durensis. You're welcome to do that as long as you keep it short, because all this is public record. Anybody that wanted to look at all the detailed plans, they're all available. So this is not a presentation to be made to the public here. This is cross-examination of Mr. Feely. So you're welcome to do a little background for sure, but let's make sure we move along.
Well, this has been the only opportunity we've had to question Mr. Feely. So I would ask the hearing officer to give us some latitude to ask questions. This isn't just about throwing some fastballs, it's about finding out some basic information. Please. It's been our only opportunity. So the first question that I would ask you are that you're as a resident of the island, you are familiar with other affordable housing projects and activities on the island. And isn't it the case that these are all pretty much located near the Surfside Crossing development?
Are you asking me if all other affordable housing developments on Nantucket are close to Surfside Crossing site?
All 40B, all the 40B projects, are they located in the Mid-Island area?
Do you have a list of which are 40B and which are not?
Well, let me ask you this. Are you aware of My Comet Village?
Of course.
Is that near Surfside Crossing?
Yeah, they're butters.
Abrams Quarry?
That's couple mile or two down the road. Yeah. Yes.
Beach Plum?
Yes.
How far is that?
I would say that's probably about a mile, maybe less.
Sachem's Path?
That's next door.
Tacoma Green?
That's on Fairgrounds Road. That hasn't been built yet.
Yes, but how far away is it?
I would guess a couple miles.
How about 31 Fairgrounds?
That's right next to Tacoma Green.
How about the Richmond development?
That's on Old South Road. That's now getting a little further.
But would you agree that the neighbors in this area have already seen all of those developments or the impacts of those developments, or are going to see the impacts of all those developments already before we consider your project?
I consider them very different neighborhoods.
But they're all nearby.
It's a small island. It's a small island, but I mean, Richmond Group is I wouldn't qualify that as nearby, and I would qualify that as the same neighbor group. I would say the same is true of Fairgrounds and Tacoma. I would say My Comet and Sachem's Path share some neighbors.
When you were picking this location for this development, did you take into consideration these other developments that were close by or not far away, and what impact it would have on the residents?
When I thought about our proximity to Sachem's Path, it was in a positive light. This area. Sorry, go ahead.
Sorry, I thought you finished. Please finish.
Well, I was just going to say the area had been identified as by planners. It's in a location. It's on the bike path. It has the bus stop right there. It's got town water. It's got town sewer. So when you talk about all of the elements that are requisite to a project like this, it's, you know, I think that's really limits you mostly to Mid-Island. You could walk to the schools from this site and some of the other sites that you mentioned, which is a big benefit.
Do you think it's fair that the residents in this area would have essentially all of the town's projects located either nearby or not far away?
Objection.
Well,
Sorry.
What's
I
your,
disagree.
excuse me,
Not relevant.
Mr. Haverty,
Mr. Feely feels it's fair or not is not relevant to this proceeding.
I can't hear him.
Mr. Haverty said whether Mr. Feely thinks it's fair or not is not relevant to this proceeding. Mr. DeRensis, how is that question relevant?
It shows it lays the foundation for the various injuries and risk of injuries that my clients face from this project.
I don't believe that question actually does that, Mr. DeRensis. I'm going to sustain the objection, and maybe you can approach it a different way.
You're a realtor. I believe you indicated in your answers and your pre-filed testimony. Is that correct?
Yes.
So have you seen, do you agree that the Nantucket real estate community has seen a fall off of buyers interested in buying in the Mid-Island area because of the presence of all these projects?
I definitely don't agree with that.
Do you agree that the properties located and surrounded by these projects have had their market value limited?
No, I don't. I actually watched what happened at Beach Plum Village have a very positive effect on that neighborhood.
Again, as a realtor, have you seen that there's been a generally island-wide a boom in real estate prices given the economy?
I have.
In your pre-filed testimony, essentially your pre-filed testimony deals with the economics of the project. As of what date does that pre-filed testimony value the economics?
I believe it's September 24th, 2020.
And how did you get to that particular date?
It was provided to me, and that's when, we submitted by that date.
Who provided it to you?
It was a long time ago now, but I believe it was determined as part of the pretrial coordination between the presiding officers and attorneys.
Would you agree in the period of time from 2020 to today, 2022, that the prices that houses are selling and condos are selling have dramatically increased.
I would say that's been the case on Nantucket since the late 80s.
And Surfside Crossing has not updated its financial statements based on the fact of market changes over the last 2 years.
Objection, Mr. Hearing Officer. Again, the date for determining economic viability was based upon the date of the execution of the pre-hearing order. Anything that's happened since then is irrelevant.
Sustained.
We were, just know for the record that we were not party to the suit at that time. So we had no opportunity to be heard on that issue. And therefore, we would object to being considered bound by things that happened before we were a party. That's just for the record. Thank you. In your pre-filed testimony, there's a reference to the fact that at one point there were different projects. So I wanted to ask you some questions about that. So as I understand it, the original project that was presented to the Nantucket boards had 156 units with 389 bedrooms. Is that correct?
I'll go with your numbers to the bedrooms, which are not off. I don't have off the top of my head, but definitely 156. Yes, 96 condos and 60 single-family homes.
And then there was a 100-unit project. How many bedrooms did that have?
I don't recall. There was many iterations of plans that were discussed during that year with the zoning board.
So you don't recall what the bedroom count was?
Well, I'm not sure it was ever one finite number, but I do not know.
And then there was a 92-unit project. What was the number of bedrooms on that?
I don't know that off the top of my head.
Do you have a approximate range?
Let's see, there's the condos, you know, I mean, if you said there were an average of 3 or 4, say 3.5 per bedroom, what's that? 276 plus 5. You know, approximately 330 maybe. I mean, it's just, that's a guess. It's an approximation.
And then there's the 60-unit project, which is the one the board approved. What is the number of bedrooms in that?
I don't know off the top of my head.
And again, do you have a a range?
There's 20 condos, which are 2 and 3 bedrooms. So if we said 2.5 there, that'd be 30. And there's 39 units or 40 units. And let's say that's let's say it's again, average of 3.5. So that would be 40, 120, 140 plus 30, 170 maybe.
And then we have the current project. That's 283 bedrooms. Is that correct?
That sounds correct.
How many people do you estimate would be living on the site with your current project?
If I were gonna guess, I would say probably somewhere in the 400s to 500 range. Assuming that, there's 2 people occupying a certain percentage of the rooms.
Okay. And I want to ask you some questions about the construction process. How long would it take in time to build 60 units as permitted?
Is there an absorption rate element to that, or is it strictly a construction question, or are you thinking of it as a development where, you
A development
look to
question.
the market?
A development question. What was the period of time that you would build 60 units over?
I'd say probably 5 years.
And
That's about the rate that we did in Beach Plum Village. I mean, I only built 30 in there, but 5 years.
And what would be the time that you would take to construct the proposed 156 units?
I think it'd be about the same.
Why would it take the same period of time to build almost 2.5 times more units?
Well, because there's an absorption element with the market. And so our experience at Beach Plum Village was to sell those cottages to seasonal summer people, which is who the market rate cottages in the 60 unit plan would go to, is much different than the absorption rate of a year-round housing product that doesn't otherwise exist on Nantucket. So I think the demand for one is very different than the demand for the other. And it's not a question of how quickly can you build the building. It's a question of how quickly will the market absorb the units that come to market relative to your ability to build the buildings.
Well, at the ZBA, didn't you say to the Board of Appeals and to the public that you were going to pre-sell the units before you build them?
I think that to the extent that we're able to pre-sell units, that would be very helpful. It doesn't, in my estimation, whether we entirely wait to pre-sell them or whether we partially wait to pre-sell, I think that it's still market driven. What's the demand for these particular units? And right now, I don't think there's anything on the market on Nantucket that's under, 1.7 million. If it is, it's just, one or two. And I haven't looked at that, but it's just been the case here for, many months, years really. So we're talking about introducing an ownership housing product that's at or under $1 million where it doesn't otherwise exist. So it's a very different market and demand.
So, but I'm not sure from your answer then, are you going to stick with the plan that you told the Board of Appeals, which was not to build until you pre-sold, or are you going to build like on a spec basis and then sell?
I think that it would be a combination.
And when you told the Board of Appeals that you were going to sell from plans, that means pre-construction, correct?
There will certainly be that option.
So if you're going to build this over 5 years, then wouldn't your calculation of potential revenues need to take into consideration the market value of your products with the built-in accelerated values that would arise over that 5-year period?
And Mr. Hearing Officer, again, objection. The date for determining consistency with local needs was set with the execution of the pre-hearing order.
Well, I'm not sure I understood the question, Mr. Durancis. Could you either state it again or maybe restate it?
The testimony was, just to explain it to the hearing officer, the testimony was that the revenues for this project in terms of its economic feasibility were measured as of September 2020, and yet the products, the housing that's going to be sold and the actual revenues received are going to be received over a 5-year period. And with the testimony that the prices of houses have been accelerating on Nantucket for some time, I'm asking him to confirm that the revenue stream would be greater by measuring the revenue expectations from the date where the properties would be most likely sold than to take a snapshot and say that everything is sold immediately on September 2020.
It's still a difficult question, Mr. Durancis. I'm going to sustain the objection. The point is, I think you've made your point. If it's relevant, I think it's almost a matter of common sense that we know prices for any development, any 40B or other development that is under consideration for years. The revenue increases over the years. Prices are going up all over Massachusetts, particularly in Nantucket. So that's a given, but I don't know that it's relevant. The whole process here is this hearing is based on, it has to be based on, can't be a moving target. It's based on the facts when this pre-hearing order was issued, and that's the basis on which we'll make our decision. and all the questions in the future about, whether the numbers come in different as the time passes, those are ultimately there. To the extent it's a problem for the developer, the developer has to deal with it. To the extent that it's a good thing for the developer, the subsidizing agency makes sure that there's no windfall profit involved. But it's not something that we need to worry about in this hearing.
Well, again, I beg to differ because part of the issue is the economics of the project. And let me ask the witness this question. As a broker, you're aware of the fact that brokers often give opinions of value, and that includes estimates as to future values over time, and that's an ordinary thing that brokers do as part of their business. Is that correct?
I think they can look to recent trends and long-term trends, but I don't think it's a broker's job to project into the future. And as much as there's been long-term trends upward, there's been short-term trends that have been sharply downward. You don't know when they're going to come and happen. And there's the cost.
You're aware of the fact that people can be hired who can do that.
That you can get an appraiser or a realtor to evaluate a property in the future?
To calculate a revenue stream based not only on what the revenue might be at some point in the past, but what the revenue would be over the life of a project. You can
Mr.
hire
Chairman, not
people
to
to do
object
that.
again to this entire line of questioning.
Sustained. And let me explain a little bit, Mr. Durancis. If we were talking about a rental thing here, that there's no question that part of the process is often to project revenues over the future, and there is some projection as to how much rents might increase, but I don't see that as relevant in this case with regard to condominiums. So at least your last specific question is overruled, is the objection sustained? And again, I'm not completely shutting off this area of inquiry, but you should, if you can find another way to approach it, please do so.
So at the ZBA hearings, one of the things I did, excuse me one moment. Yeah, I want to get into argument. Let it just aside. Mr. Feely, one of the things I did to prepare for your cross was to go through the Board of Appeals proceedings to look to see what you said to the people of Nantucket. And so I'm going to ask you some questions about statements that you made in the past. You consider the 40B process as a negotiation. Is that correct?
No.
You consider that you need to ask for more in order to get to your real number?
No.
you told the public and the ZBA that the 92 unit plan works and we would live with it. Do you recall that?
I don't recall specifically the context of such a statement. Can you elaborate on when I made it? I wonder what context I made that.
I actually have a memo in writing. If you'd like to look at it, what's the procedure?
Mr. Hearing Officer, I'm not sure why this line of questioning is relevant. The board did not approve a 92 unit plan, so I don't think it really matters to this particular hearing.
Well, on that issue, the board worked from the 92 unit plan, which the developer said was economically feasible in order to get to the 60 unit proposal that they approved. That's pretty much clear in the record. His affidavit instead starts at 156 units and takes those costs and applies them to the 60 unit project, as opposed to starting from the 92 unit project, which is where the Board of Appeals started.
And Mr. Hearing Officer, the Board of Appeals didn't start there. They denied the 92 and approved a 60 unit project in a completely different configuration of units, flipping the percentages of the for sale units and the condominium units. It's a completely different project.
The issue here is I'm asking for him to confirm his statements that 92 units worked economically.
Well, Mr. Gerais, I guess I will allow the question, but let me try to explain this so that, because it's against my better judgment in a way to allow the question, because I agree with Mr. Haverty that there really is not much relevance to this, that all through Chapter 40B proceedings, it's very common for people to consider different proposals at different points in time with different configurations, and the economics differ at varying times. And for instance, the economics can change just because of the length of time that it matters in litigation. And the developer has an absolute right to put a proposal in front of the board locally and to proceed with that. And that it doesn't seem to me that what you're driving at has any real probative value here. But if you want to ask that question again, or even read the memo and ask Mr. Feely if he remembers it, I'll let you do it. But as I say, it doesn't hurt to have it on the record, but I don't see its probative value to the relevant issues here.
Do we want to share the screen?
Don't you just read it, or isn't it sufficient to say what it is and read it? Or do you need to, I mean, if you need to share it, we'll share it, but.
If this is a document already in evidence, I can also pull it up on the screen.
Thank you.
I don't believe it's in evidence, but we do have a copy that I could screen share if that's useful to everyone.
So I'm trying to find the document here.
What is the date of this document?
It's document 8.
April 10, 2019.
April 10th?
So you want to put it on?
So I'll try and screen share it if that works.
No, that document 8. That's it. It's document 8.
I've tried to screen share and I think it's visible. Can counsel and the hearing officer see the document?
What I see is Mr. Deutsch's screen, but it's blank.
I see.
I can't see the full screen though.
I'm sorry?
I can see a portion of it. I can't see the entire screen.
I'm scrolling through the document, which appears on my screen.
All right, I see something now. Everybody see it?
So we want to be on page 2.
I'm going to scroll slowly for context for the witness.
This was sent to the Board of Appeals by Surfside Crossing applicants.
All right, see page 2.
So the bottom paragraph it says, where Surfside Crossing says, that's the we, understand, as Ed Marchant has said on a number of occasions, that every 40B is a negotiation. And then we draw your attention 8 lines down where it starts the line, maintaining our housing program, where it says, we think the 92 unit plan works and we would live with it.
Okay.
You see that, Mr.
I do.
Is that what you said to the Board of Appeals in April 9th, 2019?
That's what we wrote in that letter. That's correct. And at that time, we were pursuing a good faith effort, but it was certainly before any conditions had been worked out. And so conceptually, we were absolutely open to finding something.
And if I could have Exhibit 3.
Okay, I think we need to stop sharing the screen first, and then Ms. Loftus can help us get Exhibit 3 up on the screen, I believe.
Yes, 1 minute.
No, the plan. This is the, yes, the plan layout. Try page 3.
As I recall, this is a pretty big document, so it may take a minute to load. There it is.
Yes, that's what I'm looking for. All right, Are we ready?
Yep. You want to see sheet 3?
Yes, sheet 3 of exhibit 3. So the first thing I wanted to ask you was, is it true that there is one public road access to this development?
Just a second before you answer, Mr. Feely, I think we still have sheet 1 in front of us, or is that sheet 3?
This is page 3.
This is page 3. Okay, good. I'm sorry. Go ahead.
Should be the layout plan.
Yeah, it's entitled layout plan.
I'm going to ask the question again. I'm sorry I interrupted.
Doesn't the plan show one road, one public road in from South Shore Road to this development?
That's what the plan shows, yes.
And that there is no other public road for the occupants and the tenants, or what do you call them, the owners of these condos, other than one road in.
One road into the development or one road? Would you mind asking the question again? I'm not sure whether you're saying to the development or into the development.
One road. The only way to go from the public street to these buildings for the occupants and owners and vendors and Federal Express and so on is through one entrance.
Correct. Although there is a second emergency exit and entry.
And that's locked, is it not, with a gate?
Well, I don't know that it would be locked, but it would probably have a gate, yes.
And it's restricted to only emergency use.
Correct.
Were any of the other plans that you identified, the original 156, the 100 unit plan, the 92 unit plan, or the 60 unit plan, were any of those limited to one road in?
I believe there was a one-way in and a one-way out in several of the plans.
So there were two roads in those circumstances.
One entry.
Hearing officer, I'm going to object again. I'm not sure whether or not there is emergency access available inside this site has any relevance to the interests being represented by the abutters.
Mr. Durensis, I appreciate your moving through this kind of quickly because it seems to me at most we're laying a foundation for something. I don't quite see where you're headed. How much longer do you have in this area in your cross-examination?
Well, I would submit that the residents, not having had an opportunity to question, should be allowed a full opportunity to question without being rushed.
Well, you're only granted an opportunity to question on the elements of your case. And as I say, I right now don't understand exactly where you're going. I'm just saying that as a heads up in a way. I've overruled the objection. So either the stenographer read it back or you can ask the question again.
If you could repeat the question, that'd be helpful.
Isn't it true this is the only project plan that had only one public access road?
I think that's correct. Can I just qualify the fact that that there was many plans that were conceived and discussed throughout the process, and certainly through the architectural review committee. So when you say the only, I'm assuming you're talking about the original 156, the 92, the 60, and now this condominium version. So I'm limiting it to 4. There was a much broader spectrum of plans that were considered throughout that architectural process.
Okay, I can accept that amongst those 4. This is the only one that shows one.
I'm sorry, I'm hearing an echo. I was not able to get what was just said.
Is that something at our end?
Go ahead, Mr. DeRensis. I think you're all right.
Okay, I'm just trying to summarize what you've said. I'm accepting that amongst the plans that I've been asking you about, the 156, the 100, the 92, the 60, and the 156, this is the only one that has a single road.
That is the testimony, so please move on.
Okay. And this is the only one of those plans that was not ever presented to the Nantucket community and the Nantucket Board of Appeals. Is that correct?
Again, there was quite a few iterations of plans that were discussed as part of the architectural review that were not presented formally. So of the 3 plans that were presented, I would say that 2 of them had multiple public accesses, and this one, similar to like Sherburne Commons, has one with a second emergency exit.
Well, I didn't understand that answer. Let me approach it this way. This plan that we have in front of us, Exhibit 3, is something that you prepared and filed with the Housing Appeals Committee and opposed it being remanded back to the Nantucket Board of Appeals so that it could be considered by the local community. Is that correct?
I'm sorry, I missed the question. I mean, I was listening carefully, but what precisely is the question? Is there a way to narrow it, maybe?
All right, let's
Let me just go for the record. It's quite clear, Mr. DeRensis, on the record that this plan was submitted while the matter was pending before the Housing Appeals Committee, and therefore my assumption is it was never presented in a public hearing in Nantucket where members of the public were able to view it. They could view it anytime they wanted to in our offices or ask us to send a copy, or sure, any of the lawyers would have sent them a copy. So what in this area of inquiry, how many more questions do you have, Mr. DeRensis?
Well, I'm moving on from the traffic questions now to the question of where are the affordable units on this plan?
Okay, well, let's hold that. It's a little after 12. Let's take a break. we're going to reconvene right at 1 o'clock. The stenographer has asked that the four lead counsel stay on for just a second in order to give her some spelling and such of names. And what I would suggest is, Ms. Starr, ask whoever you have the most information about first to fill in the blanks, and then that person go eat lunch and go through the list and do it as efficiently as you can and get all that information, and we'll reconvene at 1 o'clock. Thank you.
Thank you. The first thing I have to ask is, I have no information on Mr. Deutsch or Mr. Durensis. If you could provide me with your full names and firms, again, that would be tremendous.
I'd be happy to do that. Thank you, Ms. Starr. So,
Who's speaking?
Dan Deutsch. Yes, I'm sorry, you're not able to see me? Okay. So, first name Daniel.
Yep.
Middle initial R. Last name Deutsch, D-E-U-T-S-C-H. And Durensis is Paul, middle initial R. Last name D-E, capital R, E-N-S-I-S. Both with the firm of Brooks and Durensis.
Okay.
In Boston.
Let me ask you a question. Will you be ordering transcripts in this hearing?
Yes, I believe we will.
Okay, if you could give me an email address where they can be sent to.
Sure. My first initial and last name, all lowercase, at BD, that's like boy dog, Boston, like the city.com. Thanks.
Okay, I think I'm good with you. If I could get Mr. Murphy, if he's still here.
Yes, I'm here.
Okay, could I get your full name and firm? Oh, I'm sorry. Mr. Deutsch or Mr. Durensis, who is it that you represent? They might have left.
No, I'm still here, and I'll stay on throughout this discussion. So we represent the resident interveners.
Okay.
Whose names appear in the papers that we have filed with the committee.
I don't have, but I'll just use that.
Happy to get those to you if you like, yes.
Okay. Mr. Murphy, you're up.
Dennis Murphy.
Yep.
Hill Law. My email is dgusmurphy, dgusmurphy@gmail. And the party that I represent is Nantucket Land Council.
And will you be ordering transcripts?
Yes, please.
Could I please get your, oh, yeah. No, you gave me your email address. Okay, we're good there. So I do have some spellings. I don't know who wants to give them to me, but let me do a scan and I will list them off as I come across it. Rugged Scott, is that just like rugged, like strong, tough, rugged?
Yes, Rugged, Scott.
Thank you. You said, I was unable to understand if you were saying 339 South Shore Road or 3 through 9 South Shore Road.
I believe it's 3-9.
Okay, that's good. Thank you. Cottage and Castle. Is it castle as in a castle or?
Yes, ma'am.
Okay.
And Jamie, it's cottage plus castle, correct?
It's technically it's Cottage and Castle Ventures Inc. and it's an ampersand, I think, at the state level. But we do business locally as Cottage ampersand and Cottage plus sign. So I think it's pretty interchangeable.
Okay. Okay. So just bear with me. Okay. Satan, it's, I don't know what it is. Satan's Path.
SACHEM.
SACHEM. Is there an apostrophe S?
Yes.
Okay. Ms. Boys.
BOIS.
Shop. I don't know what that was.
NAUSHOP, I believe.
And that is in Musquisset. I take everything down.
Nashaquisset is another one, and I'll probably butcher that one. So
That's okay. I can Google that as long as I have just an idea.
Nashaquisset.
Yep. And I think that's 360. Okay, so what you said was in reference to Nashop and Massaquisset. I did a project early on at Nashop, and I think that's 360 something where it's clear cut.
360 something units. And that was to the scale of the development that was clear cut.
I'm sorry to take up your time from
No,
lunch.
no, not at all.
Oh, are you aware of, sounds like, Myconnet Village?
Maya Comet Village, MIACOMET.
Ah. Almost done. Did you say Sherburne Commons? Or
Sherburne, SHERB. I think it's URN.
I think it's URNE.
URNE. Okay, thank you.
Yeah, I think it's URNE too on that one.
Okay.
Unlike the town.
I'm good.
All
I
right.
might have to do the same thing before we all leave this afternoon, but thank you. I appreciate
Great.
your
Everyone,
time.
enjoy your lunch.
Thank you. Yes.
Thank you. See you at 1.
Thank you.
said that because I was sure Mr. Murphy would be there in a second. I thank you all. Shall we continue, Mr. Durancis?
Sure.
Thank you all. So we can.
I don't see anybody. I don't even see the hearing officer, but I heard him speak.
Well, we see and hear you.
All I have is WL, which I assume is you, Mr. Hearing Officer.
That is I, but as I say, I see you and I hear you.
Is his
I can see
camera
and hear both
turned
of you.
off? What? His camera's on, audio in.
Can you fix it, or should I just go ahead? I don't want to take up people's time.
When you want to sit here?
Sometimes leaving the meeting and coming back in resets the video for you.
Excuse me, if Mr. Durancis is not visible on the screens for you as he is for me, I'm in the same room with him, but I'm using my laptop. We could change places so that he can be, we don't have to take time to reset things, and he can sit where I am instead for that period. We'll do that.
Mr. Durancis is visible on my screen.
Okay. Who's, oh, so you can't see.
I can't see anybody. I can't see the
All right,
witness.
I apologize. It's Paul who can't see others.
All I see are initials.
Well, maybe we should just proceed then.
I'll proceed, and Dan, maybe you could tell me if you know who is speaking. So I had Exhibit 3 that we were looking at, and I wanted to ask you to take the situation that there's an emergency, let's say an explosion. And if you look at the parking spaces, for example, in the upper right-hand corner, or excuse me, the lower right-hand corner, if people ran to their cars, they would be backing their cars into a road. They would be driving to the end of that road, and they would have to turn right. And if you assume for a moment that, as you testified to, Mr. Feely, this between 400 and 500 people, and with all their cars and whatever, and they're all backing up on these roads, getting in their cars and heading for that one entrance. And if you also assume that simultaneously there are fire trucks, there are ambulances, there are police vehicles, there may be DPW vehicles, all converging on the entrance, isn't it likely that there will be total gridlock?
I would say no, for a couple reasons. One, I didn't say there was 500 cars and drivers. I said there were probably 400 to 500 people that live in there. And I think it would be perfectly reasonable to walk to safety if there were an explosion, as you described. I would also say that 3 properties down to the south, where the town's project Sherburne Commons is, which is a retirement community, they have one entry in and out. and that's a dense development similar in scale to this. And they have a second emergency exit similar to this. So I just, I don't agree with the way you're describing it.
Isn't it, is it your testimony then that Sherburne Commons has 400 to 500 people residing there?
I don't know how many they have there, but I know that the property is akin in size to ours and that they have many buildings in there.
Is it your testimony that there's 400 to 500 people there?
I just
That's not
answered
true.
that.
Hearing
is it?
officer, this is argumentative. Already been asked and answered.
Did somebody say something?
No, it's been answered.
I didn't hear.
Already answered it. That's the
Motion is sustained. Can you answer that question, Mr. Durensis?
Okay. The so-called emergency exit is unpaved, is it not?
I believe so, yes, out the backside.
And it comes out into an area that's a parking lot. Is that correct?
Are you talking about Surfside Crossing?
Yes.
It comes out, when you say it comes out onto South Shore Road.
Well, it goes into a parking lot.
Correct.
And if you assume that people are backing their cars to get the hell out of there, they're going to get stuck. Is that not correct?
I don't agree with your description of this, no.
The so-called emergency entrance is only 15 feet wide.
Yes, 15 feet.
And how wide is the regular paved entrance?
Should say it right on there, but that's two-way. That's meant to be a two-way street.
Can you read it?
I cannot. Looks like
Unfortunately, I can't read it either. I need somebody to get a more 24 feet.
if you can scroll to the right, I think we'll be able to see. It looks like it's 24. And scroll up just a little bit, please. Yeah,
And the
24.
The width of a fire truck is going to need like 20 feet.
No, width of a fire. I mean, this is why we have experts from Code Red, like Jeremy Souza. But I've seen fire trucks go down roads with much less need than 20 feet. Did you say 20 or 25 feet?
I said 20.
Yeah, I mean, Amelia Drive, for example, is, probably only 10 feet wide when you drive down that with cars parked the entire length of the street. Maybe 12.
But it's your testimony. You don't know what the width is.
The width of a fire truck?
Yes.
My testimony is that's why we hired Code Red as a fire safety consultant to review every aspect of the plan.
And is it your testimony that although there's going to be a gate there, it's going to be unlocked?
I think that makes sense.
It makes sense to have it locked or unlocked?
unlocked.
Has that been decided?
No, but it can be.
Well, I'm not asking you what can be. I'm asking you, what is the project that you presented to the Housing Appeals Committee? Is it presented as a locked gate or is it presented as an unlocked gate?
Not presented as either.
Well, that proves my point. Then let me ask you, this plan depicts all condos, is that correct?
I'm sorry, could you repeat that, please?
This Exhibit 3 depicts 18 buildings that only contain condos, condominiums?
Okay, so the plan that I'm looking at in Exhibit 3 depicts 19 buildings, 18 of which are condominium buildings. One is
the community.
One is a community building.
Okay. In the plans that you presented to the Town of Nantucket Board of Appeals, the initial 156, the second 100, the 92, and ultimately the 60 unit approved by the board. Was anything in those 4 plans an all condo plan?
No.
So you never presented to the Town of Nantucket and to its citizens an all condo plan?
Correct.
Okay, I'm almost done. Let me just see if there's anything I missed. Oh yes, is there going to be a proper, you had said to the Board of Appeals that they would be a property manager for this, for your project. Is there still going to be a property manager for this project?
Yes.
And you said to the Board of Appeals that the property manager would not live on the site. Is that still a plan with this project?
So I don't recall saying that or the context in which I would have said that, but I certainly wouldn't want to exclude the opportunity from having a property manager or some of their employees live on the site. So I certainly didn't intend to indicate a prohibition against that scenario. I think that we haven't identified a specific unit that would be, for that purpose. So there's a little nuance there.
Well, let me rephrase the question. Were you going to provide a property manager with a unit at the site? You said no to the Town of Nantucket and to the Board of Appeals. Is your answer different for this new project that we haven't seen before?
So we have not provisioned a unit exclusive to the use of a property manager, if that's what you're asking me.
So then how would you enforce all of the provisions without someone there to make sure everything from rentals to behavior to whatever, when people aren't working in their home, if no one is there?
Well, let's just look at it a little bit differently. I mean, if somebody were on site, that doesn't mean they're going to be working 24 hours a day. Correct? So
I don't understand the answer, so let me ask it again. So you know that the Nantucket residents that I represent live in this area and some very close to the site. Is that correct?
I'm sorry. Would you repeat the question?
You know, do you not, that the clients I represent reside in the immediate vicinity of this project?
Okay.
If there's no one living on site available, particularly during the evening, how would this site maintain quiet, peace, orderly conduct, compliance with all the rules and regulations that might be written on paper? What enforcement plan would you have?
So if there's a real issue in the middle of the night, they could call the police, or they could call a property manager number, after hours number. And whether they were living in the development or across the street or down the road, I don't think that would be very dissimilar. And if there's a violation that needs to some enforcement after the fact, it can be dealt with the next day. But I imagine the property manager will have an office, which we provisioned for, in the community building, and regular office hours, and would be a very much a constant presence on the site during reasonable hours.
So if you go back to Exhibit 3, can you tell me where are the affordable units? Can you point out which
Mr.
ones?
Chairman, I'm going to object to this as well. This is completely irrelevant to any interests that the abutters is seeking to protect.
Mr. Durensis, why is it relevant?
We are trying to determine if the abutters are concentrated in a particular area close to a particular abutter. How is this? What is the plan?
I must say, just Mr. Durensis, I would rarely say something like this, but to hear you explain that you're concerned for your neighbors, that low and moderate income people, too many of them should live near them, seems to me to be verging on the edge of discriminatory. And furthermore, if you're familiar with the subsidizing agency requirements in any development such as this, it's required that all the affordable housing units be spread roughly evenly throughout the development. I sustain the objection.
So let me just take a moment to look at my outline and see if there's anything else. If I have a minute. I guess I do want to, on that objection, I wanted to, that you sustain. I do want to say that if I was allowed to continue to ask those questions, it would turn out that there's a history at the ZBA level about placing all the affordable units in one segment of the project and using a building like the community building as a barrier between the affordable units and the non-affordable units. And the point of the question was to see if that pattern is continuing with this new proposal that, again, we have not had it, never was presented to the Nantucket boards.
And Mr. Hearing Officer, again, I object to this. The issue of affordable unit location is solely within the discretion of the subsidizing agency. It's not something that the board can dictate in its decision. It's not something that the developer can unilaterally choose as part of its application. So again, it's completely irrelevant.
Well, in any case, thank you, Mr. Durensis, for the explanation, and let's move on.
If I could have a moment to consult with Mr. Deutsch to see if there's anything else, may I?
Certainly.
All right, no further questions. Thank you.
Thank you, Mr. Durensis. Mr. Pucci, do you have anything?
No, thank you.
Mr. Haverty, any redirect? I hope you've covered most things in previous testimony here, but if you have something.
Yes, Mr. Hearing Officer, it'll be very brief. Good afternoon, Mr. Feely. How are you?
Well, good afternoon, Mr. Haverty.
So I just wanted to cover a couple of the questions that you were asked earlier. One of the questions had to do with elimination of the pool in the community building. And my question to you is there a reason why you would not want to eliminate the pool in the community building?
Of course. I think that the pool in the community building is what's going to, create interaction amongst the residents of the community. It's a place to have the mailboxes and to have group activities and meetings and for the kids to get to know one another and interact as well as the adults. So, I think that it's an attractive amenity in a community like this, and it's part of our vision for a happy development.
So would the elimination of these amenities have an impact on the economics of the project?
Absolutely.
Okay, thank you. And with regards to the environmental monitor condition, Is the economic impact of that condition the only reason that you've objected to that?
Well, I think that first of all, I don't think that is also applied to non-subsidized developments on the island. And so there would be an unfair element as to how they are applying that requirement.
Thank you. And there was some discussion earlier having to do with the potential for restricting certain units to year-round housing. Can you expand upon that?
Sure. We had worked with a group of local, mostly affordable housing members of the community, and we had a board of selectmen as part of that, and it was basically a focus group on what can we do here to broaden the year-round appeal of the project. And we came up with a list of tenants that we thought would work well and that had unanimous buy-in by that focus group. And then we went out and we asked for got a legal opinion on how far we could go with some of these pieces. How long into the future could we restrict, for example, a unit to a year-round resident of Nantucket? And once we had that opinion, we presented to the ZBA as a potential restriction that we could apply to some of the market rate units.
And is it still your intention to include this as a restriction on certain market rate units?
Some version of it, yes.
Okay, thank you. So just to quickly address the questions you were asked by Attorney Durensis regarding increases in sales prices, presuming you were to take that into account, wouldn't you also have to take into account increased costs?
Of course.
And have costs increase during the course of this proceeding?
Of course.
Okay. If I could have exhibit, I think it's exhibit 3, Rada. Yep, exhibit 3, please. And if you could zoom in to the emergency access area at the bottom. I think you need to zoom in a little more. Yeah. Can you read that, Mr. Feely?
Yes.
All right, and what does it say about that emergency access?
15-foot wide reinforced turf emergency access.
Right, sorry, go ahead.
And it's got a little indicator that says proposed gate as well.
Okay. And can you describe exactly what that means by reinforced turf?
Yeah, so there's like a structural turf. If you could think of it in kind of layman's terms as an egg crate type of configuration, there's different types, different manufacturers. But essentially what it does is it allows for heavy trucks, such as fire trucks, to drive over them without sinking into the loam and having a stable structural driving surface, even in, torrential rainstorm, for example.
Okay, thank you. And you were also asked by Attorney Durensis about the all condo plan, and was that ever submitted to the board? My question to you is, did you ever submit an all home ownership plan to the board?
No. Excuse me, I interpreted that question the way I think you intended that question, but I think you meant to say an all single family version of the plan.
No, what I intended was an all home ownership version. So whether it's condominiums or single family.
Every plan that we put forward was 100% ownership units.
Okay. And going back to the questions relating to the on-site property management, will there be a condominium association for this development?
Absolutely.
And will that association have a board of directors who do reside on site?
Absolutely.
Okay. Only other thing I wanted to bring up, Ms. Loftus, if you could bring up exhibit on a second here. Exhibit 30D.
One moment.
Thank you. So, Mr. Feely, what does this particular exhibit represent?
That, I believe that is the I'm just trying to figure out if that's the 59 or 60 unit version. And it looks like it's the 59 unit version, which is all we could come up with. 59 unit version of the plan that the board approved that we had developed based on their conditions, or that we had asked our civil engineer to develop to the best of his ability, their ability, based on the conditions of the approval.
Okay, and comparing this plan to the 156 unit all condominium plan that is currently before the committee, how would you describe the amount of site clearing necessary?
Almost identical. One I think leaves 15.1 something percent undisturbed, and the other leaves 15.5 something percent undisturbed. So about 0.5% difference of what is affected.
And are you aware of any other attempts to show what the project as approved by the board would look like other than this plan?
No.
No further questions, Mr. Hearing Officer.
Thank you very much. Is there any recross? Go ahead.
Not on behalf of the Land Council.
Mr. Durensis?
So I have a question. May I proceed?
Yes.
So, Mr. Feely, you mentioned this this turf. Is that artificial turf?
No.
It's natural grass?
Yes.
Thank you. That's all I had.
Thank you very much, Mr. Feely.
Thank you.
We have Mr. Madden available.
Hello.
Welcome, Mr. Madden. I see you. I hope you can see me. Can everybody see everybody?
I don't have Mr. Mountain. Let me try.
Maybe I'll wait. We'll wait until you pin him.
I've got him now. Thank you.
All right. Thank you again. Welcome. And would you please raise your right hand? You solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Mr. Murphy.
Thank you. Good afternoon, Mr. Madden.
Good afternoon.
Could you please, for the record, give your full name and address?
Brian Thomas Madden, 43 Wildflower Lane, Plymouth, Mass.
And the name of your company?
LEC Environmental Consultants.
Okay. And before we get started, I just want to make it clear that you've provided written pre-filed testimony, right?
Correct.
And you testified a year ago in this same hearing once before March 5th or so. Is that right?
Yes.
Okay, so I'm not going to repeat the things that were addressed in the prior hearing, but for completeness, could you just give us a very brief background, your educational and professional experience? Thank you.
Yes. I have a Bachelor of Science degree with a minor in environmental studies from Boston College. I've been working full-time at LEC since June 2002, and I do a lot of wildlife habitat evaluations, rare species surveys, rare species habitat assessments, and permitting with Natural Heritage Program.
Do you have any specialization within the general field of environmental?
More specialties towards turtles and salamanders, state-listed species, but I do a fair amount of work and with a whole range of other species.
Okay. And are there any licenses or certificates or graduate things that you practice under?
I don't have any specific licenses. I've attended many workshops, seminars on related field matters.
And just very briefly, what's your role at LEC?
My current title is Senior Wildlife Wetland Scientist.
Okay. And what types of clients do you have just generally?
Relative broad range from single-family homeowners to we work with engineering firms on state contracts for Mass DOT. We work on peer review projects with conservation commissions and a host of residential, commercial, industrial developers.
Do you do any municipal work?
Yes, we do. Yep.
Okay. Any municipal work on Nantucket?
I have in the past. Nothing current.
Okay. Well, why don't we start with any work that you've done on Nantucket before we get to this particular project?
Yeah, so I do a fair amount of work on Nantucket. I do a lot of filings with the Conservation Commission, a lot of filings with Natural Heritage under MESA, a range of single-family home estate lot type development to subdivisions is some maybe some like infrastructure related work as well.
Have you done any of the other 40Bs on Nantucket?
Yes, I permitted the Beach Plum Village project with Natural Heritage. A conservation management permit was issued on that project.
Okay, and were you present when we spoke this morning with Mr. Feely?
I was, yes.
That's the same project that he was involved in. I was confused. It's Beach Plum Village, not Rugged Scott, that is the name of the project, right?
Yeah, I believe when we permitted initially, the Beach Plum Village name hadn't been yet created. I don't believe we had an official title to the project. It was proposed off of Scott's Way and Rugged Road.
And did you testify at the ZBA or HAC in that matter?
I did not.
Okay, so you just did the MESA permitting.
Correct. And I also attended a MEPA on-site for that project that was filed by others.
Okay. Do you happen to remember whether that is in the same priority habitat as this project, the Surfside Crossing?
So initially when that was permitted, I can't quite recall what the mapping was at that point in time. That would have been 2003 to 2005-ish. I think the permit was issued in 05 or 06. The mapping has revised several times since that point. 06 mapping change, 07 mapping change, and then 2017, and then more recently in 2021 summer.
Okay, and just very briefly, from what you remember of the Beach Plum Village, what was the end result of your MESA permitting?
The project would result in a take for the Nantucket shadbush, which at the time was a state-listed rare species. It is no longer protected under MESA currently.
And was there some mitigation for that?
Correct. Yes, we because there were some rare plants identified on that property, we transplanted them to a specific area, monitored them for a 3-year period, and there was also some buffer areas that were set aside. Those weren't restricted under a conservation restriction or deed restriction or something like that, but there was some buffer habitat management areas afforded on that one as well.
Okay. Do you happen to remember the size of the Beach Plum Village? How many units? What size the site was?
I don't know the specific unit count, or I can't recall. Those were all standalone single-family dwellings.
And if you were here this morning, you heard Mr. Feely mention that it was somewhere on the order of 4 or 4.5 units per acre. Does that square with your understanding?
Possibly, yeah. I mean, I want to say maybe there was around 40 plus or minus, and maybe I want to say it was a 10-acre site, so that seems to match up.
Now, Mr. Feely also mentioned that there was a park. Was that any of that land set aside for the MESA process at Beach Plum Village? You mentioned there was a take of some kind of species. I didn't catch the name.
Nantucket shadbush, a rare plant at the time.
Okay.
Yeah.
What was the park put there so you'd have a place to transplant this shadbush, or?
Can you clarify, Park? Are you talking specific to the interior of the site?
Yes, I understand there's an open space area at Beach Plum Village that was set aside as a park. And you just said a few minutes ago that you had to transplant some of these rare species. Did they get moved to that park or somewhere else on the site?
They were moved to an undisturbed area within I believe it's the southeastern corner of the site.
Okay.
Outside the development footprint.
Understood. So let me ask, could that same phenomenon happen with the Surfside site? That is, if there were rare plants, could they be transplanted and preserved somewhere else in an undisturbed area?
Yeah, I believe so, through the proper permits. I mean, I think that's exactly what happened on Sachem's Path.
And also on Beach Plum Village.
Correct, yeah.
Okay, I'll ask you about Sachem's Path in a minute, but yeah, thank you for prompting me on that. Is that the current plan for Surfside Crossing, to transplant any of these rare plants?
I'm unaware of any rare plants on Surfside Crossing property.
Okay. Well, we'll get to that. But since you brought up Sachem's Path, let me ask, and just to cut to the chase, if we could, that place looks a lot like Beach Plum Village, doesn't it, in terms of its density, the size of the project, 40 units on 10 acres or so. Is that right?
Density, I would defer to others on the exact density count. But are you talking pre-development conditions or current?
Well, my understanding is it's a 9+ acre site and it has 37 units, and Sachem's Path, I believe, is the one that has the acre that is subject to a CR that's undisturbed. Is that right?
That's my understanding, yes.
Okay. And it also has an undisturbed buffer around the perimeter. Is that your understanding as well?
Yes, I believe there's a 25-foot buffer along a portion of the southerly property boundary that adjoins Surfside Crossing. I think it stretches for around 450 feet and then extends up to the north along the westerly property boundary and narrows down a little bit less than 25 feet and then links up with the 1 acre conservation restriction area.
Now, I'm asking you all these sort of background questions. Here's really the nub. As an ecologist, is there some significance to the different types of environments you're talking about? That is, are there plants and animals that would thrive within the confines of a 25-foot buffer or in a 1 acre undisturbed zone?
Certainly, there are some plants and animals that would thrive in those conditions.
Let me ask it the other way. Are there any that won't persist in a 25-foot perimeter buffer, but that would require a larger undisturbed area like the acre that's set aside at Sachem's Path?
I think I'd have to give it a little bit more thought or understand what animals or plants you were referring to.
Well, just the ones that you identified at the Surfside Crossing.
So I mean, put it to perspective, the habitat conditions pre-development on Sachem's Path are different than they are on Surfside Crossing. I think Sachem's Path had some sandplain grassland habitat along with some sandplain heathland habitat where the rare plants, the New England blazing star, were identified. And I believe there was some transplantation that took place on that one as well.
And did you or your company do that work at Sachem's Path?
No, I believe someone had asked us to potentially get involved with the RFP in the early bid process, but we were not involved with any formal aspect of that project.
Do you know who did the work?
I believe it was Horsley and Witten.
Okay. Now, if I could, let me ask you, we've talked about these two other 40Bs in the same neighborhood, Sachem's Path and Beach Plum Village. And you were involved in the Beach Plum Village directly, right?
Correct.
Is there a reason from your perspective as a wildlife and ecologist, wildlife biologist, ecologist, that you couldn't set aside some space to preserve the habitat on the Surfside Crossing site that is similar to what was done at Sachem's Path or Beach Plum Village?
Well, we would defer to natural heritage on what the requirements would be for habitat protection, buffer setbacks. I mean, I think in their MIPA comment letter, they talk about assessing alternatives to maximize that buffer setback.
Is the difference in the mapping?
Between the two sites?
Well, there's three of them, yes, but among the three sites.
Yeah, I think currently they are separately mapped as priority habitat. It basically boils down to on-site habitat conditions at each of those sites individually.
Okay, you're talking to a non-expert, and just for my own edification and everyone else's, if you're on a site and you stumble upon a protected plant, a blazing star, say, do you have to protect that, or only if that particular patch of earth is mapped at natural heritage?
If a rare plant was found, then there are reporting mechanisms to the state through a online database type program. And typically, if a rare plant was found during our consultation with Natural Heritage or permitting with Natural Heritage, we would contact them and we would review what the required next steps would be.
Okay. Well, I'm going to tax your memory a little bit because I realize it's probably been almost 5 years at this point, but can you tell me when you first visited the site, the Surfside Crossing site?
I believe it was August 9th. Well, for Surfside Crossing or for Jamie Feely directly, I visited it on August 9th, 2017. But I had been on the site previously, I believe in 2015, under a different client.
And who was that?
It was through Site Design Engineering was my client. I don't know who they were specifically working for, if it was the property owner at the time or someone else, I do not know.
And what was the purpose of that initial visit before you were there for Surfside?
It was a habitat assessment relative to the rare species list that Natural Heritage had generated at that time.
Okay. Was there a project involved, or this was just out checking out the woods?
Yeah, my understanding was just early due diligence. I never saw any plans previously proposed.
Okay. Okay. So that initial 2015, that was under the prior atlas, right? The prior version of the Natural Heritage Atlas?
Yes, there was an update on August 1st, 2017. And that's the reason why a new MISA information request was submitted by my office in August 2017.
And were there any species added or dropped between those two editions of the atlas?
My understanding is, or my recollection is, no, there was the same 6 rare moth species that were identified on both lists.
So you basically were just confirming something because there was a new atlas based on your prior field work. Is that right?
Correct. Yeah. I mean, Natural Heritage database is always being updated, so we like to obtain current data.
Okay. So now turning to when you first went on for Mr. Feely and Surfside, were you there specifically just to look for those 6 moth species?
Not specifically looking for those moths, effectively analyzing, assessing habitat conditions that may function as habitat for those rare moths.
But for any other species, like you mentioned the blazing star, were you looking for that at all?
Not specifically, because it wasn't a mapped or identified species at that point in time.
Okay. So I understand the remit of a ecologist is that you go to a site and you're looking for what the atlas says is priority or estimated habitat, rather than just looking for anything that happens to be on some protected list. Is that right?
In terms of moving something forward or doing early rare species due diligence, it's based on the rare species list provided at that point in time and what the implications may be for any future potential development.
Okay. And when you were there that first time for Mr. Feely and Surfside, what did you find?
Generally heavily vegetated site. It's primarily dominated by partially open pitch pine canopy. with a variable dense understory, scrub oak, bayberry, black huckleberry, with some scattered interspersions, openings of herbaceous vegetation, primarily Pennsylvania sedge and little bluestem.
And did you at that time produce any kind of report or record, or I understand people now, they geolocate where they've been and what they saw. Did you produce any document from that site visit?
I think in the early consultation with Natural Heritage, I gave a brief overview of what woody vegetation was present on site and what range of percentages it was comprised of, because most of the state-listed rare moth species have specific host plants. Something like scrub oak is a typical host plant, so it's important to understand, what portion of the property or percentage of the property is comprised of those species.
Let me ask, at that time, was there, as part of your due diligence, was there any discussion, or were you asked, can the site be clear cut?
I don't recall that specific conversation coming up. Any areas within mapped natural heritage priority estimated habitats, any non-exempt work activities cannot take place without review. I reviewed that at least with Jamie.
Okay. And then at some point, I understand either maybe between your visits to the site, there was a moth specialist named Dr. Mello, and he did a Lepidoptera survey. Is that my understanding correct?
Correct. He had performed a survey in the past in 2016, and he had completed a supplemental moth survey for Surfside Crossing in summer 2018.
And do I have it right that he was brought in because he's a moth specialist, and that's what this site was mapped for, was for these moths?
Correct.
And you're just a general, not the moth guy, and so we bring in Mello. Is that just basically what happened?
Yeah, I mean, I can certainly analyze habitat assessment, habitat conditions for those species, but when it comes to actually performing a formal field survey, there's a short list, and Mark Mello is the go-to guy in the state.
Other than Mark Mello, did anyone else perform a field survey at the site?
Not to my knowledge.
So you didn't do a field survey?
Identifying a specific plant or animal, no.
Okay. Let me turn now to the timing. I noticed that you were on the site, I think you said in August of 2017, and I believe Mr. Philly closed on the property the following month. Is that right?
If my recollection is correct, I think he had a due diligence expiration at the end of August. I don't believe he closed on the property until October officially.
Okay, but what you were doing at that point was determining whether or not, or advising your client about whether or not he should even buy the site. Is that right?
Yes, performing rare species due diligence, understanding what the state-listed rare species concerns would be through natural heritage, and what the permitting requirements may ultimately look like.
Okay, and did you advise him to buy it, not buy it? Did you have an opinion? Were you asked?
I don't make those type of recommendations. I just lay out the groundwork of what the permitting requirements would be.
I understand. After that initial visit, have you been back to the site?
Yes, I've been out to the site several times.
And let me just ask a kind of a general question about how much time do you think you've spent doing your field work at the site cumulatively?
Talking hours or days?
Yeah, hours. Oh, if it's days. In just a ballpark.
Yeah, I think I've probably been out on the site at least 5 times, anywhere ranging from an hour to 3 hours.
Can you do a field survey in half an hour on this site?
A field survey that would be approved by Natural Heritage? No.
Well, you've done over your 20 plus years, you've done a number of these. You know it's a 13-acre site. That seems like a big ask, doesn't it?
To do a field survey in a half hour?
Yes.
Yeah, so any field survey that would be required by Natural Heritage, you have to submit a protocol in advance, be approved to do that survey for that particular species, and then you outline exactly your methodologies for surveying for those species. And if it's rare plants or rare animals, timing is of critical concern, and you basically outline the time extent that you would propose to perform that.
Understood. But not every field survey is done under the auspices of Natural Heritage, is it?
If it's required by Natural Heritage, then yes. Are you talking more of a general wildlife survey or plant?
Yeah, look,
survey?
I mean, the first time you went on the site, you weren't that you were there at the request of Mr. Feely, who was thinking about buying it. You weren't there for some permitting of Natural Heritage, were you?
That's where my directive or goal objective was leading towards what a Natural Heritage permitting outlook would look like.
Okay. Let me turn your attention now to, well, before we go to the next topic, let me just close this out. Do you know who Dr. Sarah Boyes is?
Yes, I do. Yep.
Okay. And when she came to visit this site a few months ago, you were supposed to meet her, right?
I was, yes.
And my understanding is it was too cold to fly that day. Is that right?
My flight was canceled due to mechanical issues, and my flight was canceled, so I was unable to make it over there.
If you were there, I think it would have taken more than half an hour to look at the site, the whole 13 acres?
Well, my understanding was that the intent of the site evaluation for Sarah was to replicate the on-site that took place last year that she had missed.
Okay, but she's a PhD level ecologist, just like you, right?
I'm not a PhD, no.
Okay, but you're an ecologist, and you've been on these sites. My basic point is, would you have been able to do the work she was asked to do under the same conditions?
It wasn't my understanding that her site evaluation was to conduct a formal survey of any kind.
And that might have been a misunderstanding, but I guess let me just ask the very basic question. Would you be able to glean the information that you would want to have as an ecologist from just a half an hour looking at 1 acre or less of the site for what's on the other 13 acres?
I guess I would have to better understand what the ultimate goals and objectives were and what permitting forum you'd be in, but
Okay, well, let's move on. So,
Excuse me, could I interrupt here briefly? Before we move on to another topic, would it be possible to take 5 minutes?
Absolutely.
Of course.
Let's take 5 minutes. It's exactly 2:05 and we'll reconvene at 2:10.
Thank you.
thanks.
Let's give Mr. Durensis and Mr. Deutsch a minute or two, Mr. Murphy, but then we'll get started.
Thank you very much.
I'll repeat what I just said. We just give Mr. Durensis and Mr. Deutsch a minute or two, and then we'll get started. There's Mr. Deutsch.
Yes, I am. Mr. Durant's is just using the restroom, but since we're represented here, we're content to have you proceed. He'll join us shortly.
All right, well, thank you.
Thank you.
Murphy.
Okay, thank you. Mr. Madden, if the roles had been reversed, and let's say Dr. Boys was actually, you were peer reviewing her work and she was in your position, would you have been able to effectively peer review her work in a half an hour on the site in January?
Peer review work in regards to the MISA regulations?
Well, you said that you've been to the site half a dozen times and have spent hours there in your own due diligence, right?
Correct. Yep.
And if Dr. Boys had done that and you were brought in to do peer review is my word, but somehow a second opinion or a double check, could you have done it in the limited time in January that she had?
I go back to the goals and objectives of any site evaluation. All my work has been in the context of what natural heritage has required us to perform or the applicant to perform or to analyze. Never have we been tasked with doing a general wildlife plant survey from natural heritage.
Can you tell me what the current iteration of the project is?
The 156 condo units within 18 buildings.
Yes. And 299 parking spaces, is that your understanding?
That is my understanding. With some banked parking spaces, is my understanding.
And you prepared the ENF, right?
I did, yes.
Okay. And wasn't one of the MEPR triggers the fact that there's over 2 acres of disturbance to priority habitat?
And the project resulting in a take of state-listed rare species.
So I'm not going to make you do math like I think occurred earlier, but with 156 units on 12 or 13 acres, I calculated density somewhere along the lines of 12 units an acre. Does that sound right to you?
Sure, I'll defer to you on that math.
Okay, and when we were talking earlier about Sachem's Path and Beach Plum Village, you also agree that those are about 4 units per acre?
Yes, I believe that's what we talked about.
Is there something particular to the Surfside site ecologically that justifies 3 times the density of those other nearby sites?
Density, I often, in my world, we don't get into density really from a numbers perspective. We're largely looking at the overall impact on the development footprint as a whole in relation to habitat conditions and what rare species have been documented on or within the vicinity of the site.
Yeah, but it relates to how much of the site can be preserved, how much must be paved, how much can be left for buffer or open space, doesn't it?
Sure, it factors in design, absolutely.
Okay. I think it would be helpful if we could put up Exhibit 12, which is Mr. Madden's ENF. It's actually the supplemental narrative, Ms. Loftus.
One moment.
Thank you. And if you could, there's a page 6 of 8 that has a chart on it. Attorney Loftus.
Yeah, I think it's 6 of the narratives, so it's probably further down.
Yes.
Do you have a page number?
It's 6 of 8. Once you get to the narrative portion, this is just the form. I don't know the PDF page.
I believe the narrative should be right after the form.
Mr. Madden, you're obviously familiar with your document. I wouldn't even bother to put the exhibit, except it's a chart that has numbers that you can't possibly have in your head.
I think I do, but certainly pull it up.
Okay.
Thank you.
Sorry, my PDF application is frozen. Just rebooting it. It'll be one moment.
Yeah, in the interest of time, I mean, we could move to another topic and come back to this if you like. I can just ask you while we're waiting, Mr. Madden, were you ever asked, your chart references various iterations of the project, 156 units, 100 units, and 92 units. Were you ever asked to do an analysis for the 60 units that were approved by the ZBA?
No, I know the engineers had worked on a plan and I'm familiar with that plan.
Would you agree that generally with fewer units, you have less need for impervious coverage and greater opportunity to preserve open space or undisturbed areas?
Possibly, but I believe that 59 unit layout that Bracken Engineering had provided, it was up earlier on the screen. The development impact is somewhat similar, comparable to the current proposal. Based on what the conditions I believe were included within the ZBA's comprehensive permit.
Okay, thank you. Well, now that we have Exhibit 12, and particularly that chart I referenced, does this look familiar to you?
It does, yes.
And I just want to call your attention, the right 2 columns are the 92 units and the current 156 condo alternatives. And let me just ask you, in the lower row, you have figures for undisturbed acres. Do I have that right?
Correct.
And could you tell me what the delta is between 92 unit and the current 156 condo project?
That would be about 0.96.
Okay, so
acres.
it's almost an acre more of undisturbed area under the 92 unit version of the project, right?
Yes.
And if you look at the second row down, impervious acres, those same two columns is the delta. It looks almost to be an acre and a half. Is that right?
Yeah, 1.38.
Okay. So that gets to my question. At 92 units, it's more opportunity to preserve open space, less impervious coverage. You agree with that?
Correct. Yep.
Okay. We can take down Exhibit 12. Thank you. So when Dr. Mello was asked to do his survey, I just want to see if I can understand. You didn't see any moths in your site visit, did you?
No, that was not the purpose of actually physically identifying moths.
Okay, but that was his purpose, and he was asked to do that because that patch of land was mapped for those species, right?
Correct, to supplement the prior survey that had been performed.
Okay, but he was only looking for moths.
Correct.
Butterflies, Lepidoptera, and you weren't looking for anything in particular when you were there doing your site investigation, were you?
No, I have not performed any formal surveys.
So my question is, has anyone done a survey of the full 13 acres of what endangered species might exist on the site?
No, natural heritage does not require any surveys to be performed.
Okay. Can I ask you, in your prior testimony, you mentioned that after a ENF certificate is issued, you would be applying for a conservation management permit. Have you done that?
The application has not been filed. We've had some consultation with Natural Heritage about materials that would be required to be accompany the application, but that has not been formally submitted yet.
Do your conversations basically align with your prior testimony about what will be in the conservation management plan?
Yes. We've had some consultation with them on one of the comments that they made in the MIPA comment letter was relative to assessing alternatives to maximize the vegetated buffer around the perimeter of the site. That is something that we have reviewed with them to maximize that buffer. And we've had some discussions about more detailed aspects of the mitigation, conservation, and management plan for off-site land protection, conservation recovery, research, habitat management, that aspect.
And is the current plan still to do 20.34 acres of off-site mitigation for this?
I believe so. Those numbers will be finalized or memorialized through the conservation management permit review process. So, that would be reviewed with Heritage at that point in time.
And is it still the plan that 20 acres will be somewhere else, not, well, let me just ask it this way. Is it going to be on Nantucket?
I believe it's my testimony that it's the applicant's preference to have the mitigation be on island.
But I know that's your testimony but you said you just had a conversation. Is that still the plan?
Correct. Yes.
Okay. And am I correct that the conservation management permit is really directed at one particular moth, this cutworm moth?
Yeah, coastal heathland cutworm.
Okay. In your experience, are any kind of preservation, open space, or habitat, is it usually tied to some species protection?
Yes, if I understand that question correctly.
I mean, that's the way the rules are set up, right? The whole MISA.
Oh, you have
regime.
to have a direct benefit for the impacted species. Yes.
Okay. You know, I have some questions, but Mr. Feely, your client thought you were best positioned to answer about the Nantucket Open Space Plan. But before we call it up, let me just ask you, are you familiar with that?
I'm currently familiar with that plan, yes.
And do you use it in your work on a regular basis?
Not necessarily. My understanding that the open space and recreation plan is a conservation and recreation planning tool. It's not a regulation. And there's a series of goals and objectives as part of that plan, but it's not a regulatory application.
Well, were you aware that it's also part of the town's master plan?
Yes.
It's incorporated as Exhibit J, I believe. And you also know that the master plan was adopted by the planning board and town meeting?
I believe I heard that earlier, this proceeding.
Okay. So let me just ask, in your site investigation and due diligence and everything that you've done, was the open space plan a document that you were consulting in order to do your work for this site?
Not per se. Again, I was involved or am involved directly with the natural heritage permitting aspects.
Okay, well, if it wasn't something that you were, I'm sensitive to the time and I'm not the last person to question. I don't want to pull up another document, and it is 450 pages. If it's not something that you were basing your advice on and trying to comply with, then we can avoid that. Do I understand your testimony that you regard the open space plan as a guidance document and not a regulation?
That is my understanding.
And did you follow its guidance?
I believe in that page. I think maybe you were going to call up that page 135. It talks about general recommendations for land protection strategies for the town.
Yes.
Yep.
Yeah. So do you have an opinion about that? Whether in fact you and the applicant followed that in this case for Surfside Crossing?
Well, my understanding of the plan, again, is that this was a guidance doc for the town to identify lands that should be protected or preserved for open space to protect plant and animal habitat while balancing a variety of needs like affordable housing. I believe that's one of the goals, objectives of the plan.
Yeah, I mean, it actually says that a wildlife survey should be conducted within priority areas, doesn't it?
It does, as a recommended general recommendation.
Okay. I'm mindful it's a document in evidence. I'm free to talk about what it says in my post-hearing brief. I don't need to get this in through a witness, so I'm not going to bring the document up. Let me just ask you in closing, Mr. Madden. Do you know a guy by the name of Bruce Perry?
I do, yes.
And who is he?
Bruce Perry used to be the technical consultant for the Conservation Commission. He had worked for the Land Bank as well.
And how do you know him?
I think we've interacted on Land Bank projects or projects I'm working on adjacent to Land Bank properties in the past. He was reviewed a variety of my applications when he was the technical consultant with the Conservation Commission.
So he does similar work to what you do, right?
He was the effectively the town's peer review on applications for a number of years. He doesn't.
Have you ever done? I'm sorry. Go ahead.
Apologies. So he doesn't file applications. He reviewed the applications filed by others.
And has he ever done any work for you?
No, I don't believe so.
Okay. Do you know if you mentioned earlier that you thought Horsley Witten did the work at Sachem's Path? Is there any chance it was Mr. Perry who did that?
I don't know whether or not he was involved. I believe Horsley and Witten had filed a conservation management permit with Natural Heritage.
Okay. Is there anything that you want to clear up from your testimony so far today?
I don't believe so.
All right. Thank you, sir. That's all I have. Thank you very much.
Thank you.
Thank you, Mr. Murphy, and thank you for noting that you don't need to read things from something in evidence. Some people don't observe that. It's very much appreciated. Next, Mr. Deutsch or Mr. Durensis.
I don't have any questions for Mr. Madden. Thank you.
Thank you. Mr. Pucci.
No, thank you. Nothing. Thank you.
Mr. Haverty.
Yes, thank you. Good afternoon, Mr. Madden.
Good afternoon.
So you were asked about whether or not there would be a buffer along the Sachem Path property. Is that correct?
Correct.
And what exactly will be the buffer zone that'll be provided along that property on the Surfside Crossing property?
What will likely, or what we're working towards inclusion in the conservation management permit application is incorporating a 25-foot vegetated buffer around the entire perimeter of the site.
Okay. But in particular, there will be a 25-foot buffer along the Sachem's Path?
Correct.
Property? Okay. So in your original testimony, you had testified that there was a take letter issued by Natural Heritage on this project. Is that correct?
Yes.
And what species did that letter indicate would be taken as a result of this project?
The coastal heathland cutworm.
Okay. Were there any other species that were identified in this letter?
No.
Are there any other species that are shown as priority habitat on the Natural Heritage maps?
Not to my knowledge.
Right. So did the take letter identify northern long-eared bat or New England blazing star?
No, it did not.
And was there an appeal of this determination?
Yes.
And are you aware who filed that appeal?
The town, the select board, and the Nantucket Land Council.
Okay. And what were the species that were the subject of that appeal?
I believe New England blazing star was discussed early, but ultimately I think the crux of the discussion or review is based around the northern long-eared bat.
Okay. And what body was this appeal filed with?
The Division of Fisheries and Wildlife.
Right. And was there a decision issued on this appeal?
Yes, the presiding officer had issued a final decision upholding Natural Heritage decision.
Okay, and was this administrative agency decision appealed?
Yes, by the Nantucket Land Council.
Okay, and what was the result of that appeal?
The Superior Court did uphold the natural heritage decision.
Right, and to the best of your understanding, is that appeal process now complete?
I believe so, yes.
Okay. Is there any additional permitting necessary from a endangered species aspect for this project?
Yes, as I mentioned previously, the conservation and management permit application will be filed with Natural Heritage.
Right, and have you begun preparing the materials necessary for that filing?
Yes, to some extent, we have consulted with Natural Heritage on what would be required.
Right, and you made some comments about providing a 25-foot buffer all the way around. How would that be arranged? How would you be able to do that?
So under the 156 condo unit plan, there's a variety of walking paths connecting to the units that extended into the buffer. Basically involve relocating those walkways, possibly shifting building or parking areas a couple feet to maintain that 25-foot buffer. If there's any encroachment into the 25-foot buffer, that would be revegetated with native species, and in all likelihood, a declaration of restriction would be placed over that 25-foot buffer area.
Okay, and when I was redirecting Mr. Feely earlier, there was a discussion of the 59-unit plan in Exhibit 30D. Do you recall that?
Yes.
Do you need that plan brought up to review, or do you remember it well enough?
I do remember it.
All right, and so if you could you compare the impacts of that 59-unit plan to the impacts of the 156-unit plan as it relates to undisturbed area?
Yes, I believe that 59-unit plan incorporates a 25-foot buffer around the perimeter, which would be comparable to what would be included within the conservation management permit application.
Right, and if that 25-foot buffer is provided in the 156-unit condominium development, will the undisturbed area for that be similar to the other various proposals that were reviewed earlier?
Yes, I believe it would be somewhat in line with the 92-unit alternative.
Okay. So with regards to the open space plan and the question of whether you would perform a survey of basically all the entire site for all endangered species, is that something that you would typically do on a development project?
No, we would defer to Natural Heritage on what we specifically would need to investigate and whether or not any surveys would be required.
So it would not be typical to do an endangered species survey of a site that's not mapped as priority habitat?
Correct.
Okay, no further questions.
Briefly, if I may,
You may.
You'll note for the record, you did not hear me say the word bat until just now, but Mr. Haverty did. And so I just have a couple of questions since he opened the door. Mr. Madden, you're an expert in endangered species, right?
Yes, not specifically specialty towards bats. I'm not a bat expert. I think I testified to that previously, but generally more of an expert, rare species and rare species permitting in Massachusetts.
Well, do you follow what the United States Fish and Wildlife Service does with various species of concern?
I am aware of it, and you're referring to the 4D rule?
Well, I'll get there, but why don't you tell me, what is the 4D rule?
The 4D rule is specific to the northern long-eared bat that stipulates or prohibits tree clearing within a quarter mile of hibernacula for the species, or within 150 feet of a documented maternity roostery.
And 4D, if
sorry.
I'm correct,
I'm very sorry. I did not hear what you said. Of the species or with 150 feet of a documented
maternity roostery, and just to expand upon that or clarify, in June and July is what the 4D rule states.
Mr. Madden, does the 4D rule apply to endangered species or threatened species?
To my knowledge, it only applies to threatened species.
And currently, the northern long-eared bat is designated as threatened under the Federal Endangered Species Act, correct?
Correct.
Is threatened worse than endangered? I mean, which is?
I believe, Mr. Lowy, that in the order of magnitude, threatened is yellow and endangered is blinking red.
Thank you.
Sure. Mr. Madden, what would be the effect if the northern long-eared bat was redesignated as endangered?
My understanding is that there is a current proposal by Fish and Wildlife to list the northern long-eared bat as endangered. There's a hearing on that next month and a 60-day public comment period with a conclusion decision anticipated by November 2022. If that all goes through and the northern long-eared bat becomes endangered, the 4D rule would no longer be applicable.
And what does that mean for your conservation management permit and for this site?
I don't believe I have a definitive answer to that. Any consultation with Fish and Wildlife Service may be required, but as the project currently stands, there isn't an apparent need for Section 7 consultation at the Fish and Wildlife federal level, as there is no federal nexus. There is no federal permit required or authorization for this particular project, to my understanding.
Are you aware of why Nantucket in particular is important for this species, the northern long-eared bat?
Yes.
And why is that?
So the northern long-eared bat population has been decimated by white nose syndrome, which has resulted in a lot of die-off of the species. To my knowledge, there's only been 1 or 2 cases of documented white nose syndrome on Nantucket for northern long-eared bats. The studies of the species are relatively new, within the last 5 to 7 years. I'm not aware of any current data within the last couple of years.
If in fact Fish and Wildlife, the federal Fish and Wildlife changes the designation, will you recommend to your client that this site be field surveyed for the northern long-eared bat?
I would recommend that we consult with Fish and Wildlife on what the required next steps may be, and/or natural heritage.
You recognize that Nantucket is one of the only places where this white nose syndrome is not killing all of them. And my hope is that between you and your client that we'll at least figure out if this is a site where they might roost. And thank you for your time today.
Thank you.
Thank you very much, Mr. Madden. I assume you don't have anything else, Mr. Harry?
I didn't know if Attorney Pucci or Attorney Deutsch wanted to add anything.
Nope, not me.
Okay, I guess we're all set then.
But thank you very much. And thank you, Mr. Madden.
Thank you.
So, what we talked about before is there were several witnesses on behalf of either the Nantucket Land Council or the residents or both, that Mr. Haverty was trying to decide whether he was going to cross-examine or not. And I think that's what we need to address right now.
And Mr. Hearing Officer, I don't see the need to call any further witnesses.
Okay, thank you. In that case, I think we've heard all the witnesses that people want to call. Am I correct?
Yes.
So, good. Thank you for an efficient day. It was worked pretty well. I appreciate your cooperation, all of you. Our normal practice, which seems to me we would follow here, is to ask you to file briefs 30 days after the transcript is received, which typically is pretty prompt. Does that make sense to everyone?
That makes sense to me.
Yes.
Good. Is there anything else that we need to do here today?
Mr. Hearing Officer, I would ask as a housekeeping matter that the document that Mr. Durensis displayed to Mr. Feely and about which there was testimony and it was authenticated, that was the letter of April 10th, 2019 to the Zoning Board of Appeals, be admitted and marked as exhibit. I think 73 would be the next exhibit.
Is there any objection to that?
No objection.
No objection.
You'll admit that as exhibit 73 and leave it to council to make sure it's filed.
Yes. We'll do so.
A couple other just, sort of housekeeping matters. And I should also say, by the way, just so the record reflects it, when we discussed today's hearing session during our pre-hearing conference last week, I said that I thought in general that opening statements and closing statements in this situation were probably not all that useful. And I think, and I assume that that's why I didn't bring it up here again. If anybody really felt strongly that they wanted to make a closing statement, I'd be happy to hear it. But the briefs are always much more valuable.
I didn't have a closing, Mr. Lowy, but I did want to raise the issue of the site visit, and it may be just a clarification. We took the order to mean that our expert was going to be allowed to do field work and not like a member of the public, just view what the public viewed, but actually do what she's trained as a PhD ecologist to go and view the site. And I believe that's what was intended by the order. I think it was a simple misinterpretation. If I'm right about that, then my hope is we have time while this transcript is being created before we close the record of this to actually rectify this situation and see if we can't really clarify who's allowed to go how far and for how long.
And Mr. Hearing Officer, the motion for site visit specifically stated that Dr. Boyce's testimony about the ecology of the site, its habitat, and utility as open space, key issues in the NLC's case, would be hampered if she has not been permitted to examine the site about which she will be testifying. In order to avoid prejudicing NLC's case, its expert should be accorded the same opportunity to other parties in the pre-remand hearing to visit the site. That's what they were asking for, is the same opportunity that was accorded to other people during the original site visit. And I would point out that after the order allowing the site visit to occur was issued, I did reach out to Attorney Murphy. I indicated my clients would allow to have Ms. Boyce on the site. I stated that she would be accompanied by Brian Madden from LLC. She'll be given access to the cleared areas of the site that were part of the original site walk, and we anticipate the site walk will take no longer than 1 hour. I followed up and asked for confirmation. Attorney Murphy sent me an email saying that he confirmed it, and he did not object to any of these terms that were contained in my email.
When did she actually visit the site?
It was the coldest day of the year on Nantucket. I believe January 11th, It was so cold that Madden's plane couldn't fly. So that's why Mr. Feely had to go.
Well, Mr. Murphy, the difficulty with what you suggest is that the evidentiary portion of the hearing is now closed. So if Dr. Boyes were to go on the site now, I don't see how it would do you any good.
Well, if it was, I understand that she's not going to be recalled to testify, but it looks like Mello was there looking for butterflies and moths. Madden was there not looking for anything in particular and not really doing a full field survey. And it just strikes me as, if they weren't looking to clear cut the 12 acres without even knowing what's there. That's what Boyes has. She's a PhD level ecologist. She'll be able to, she's not under some mandate from natural heritage to look for just one species. So that was my hope, was to clarify what the initial ruling was. And I really believe that the restriction was based on a misinterpretation.
Well, it's rare that I write an order, as I did in this case, that there can't be some misinterpretation, and who knows whether there was or wasn't. But if that is the case, and she was there on January 11th and there was disagreement as to what she should do, that was the time to raise the issue. It's now more than 2 months later. The evidentiary portion of the session is closed. If you were to file something in writing, the other parties would certainly need an opportunity to respond to that and to cross-examine her. And this was the time set to do that. And therefore, I don't see any solution here, it seems to me. And I would also say that it's quite unusual to allow. I don't know that I've ever issued an order in a case like this to a site owner to require them to allow an opposing expert access to their site. And if you were not satisfied with the access that she was given, I believe it's too late to raise it now.
Well, it was raised in her pre-filed testimony, which was filed the week of her site visit.
Wasn't raised.
I thought we might.
I don't see testimony the minute it comes in.
Okay, I'll just make reference in Exhibit 60. She does devote paragraph 13, nearly half a page to that January 11th site visit, and she was only permitted to survey a small portion and not able to view even a full acre. A comprehensive environmental survey is essential prior to allowing development or clearing. That's basically her testimony as of January 13th. Maybe I shouldn't have waited till today to get that clarification, but I honestly didn't know until Mr. Feely testified this morning what the misunderstanding was. But I accept the ruling for what it is, and thank you for reconsidering it.
You're welcome. As I say, when the transcript's received, we'll count 30 days from then. And we normally ask someone of council to finalize the official list of exhibits. And I don't know, it seems as though many of them were filed by Mr. Deutsch. I mean, it doesn't really matter who does it. It seems to me it's a pretty easy matter at this time. I circulated a Word document that had at least briefly the exhibit 60 through 70, they maybe should be expanded a little clearer. And then three documents need to be added to the list, and then we will, in our office, we can put some sort of stamp of approval on it. Who's in the best position to do that little bit of work to get it in final form? Is it possible to do that, Mr. Deutsch, or is it better for Mr. Haverty to do it? Who should do it?
Excuse me, Mr. Hearing Officer, you're referring to the list of supplemental exhibits that was circulated in advance of this hearing session?
Correct.
I did review that list, and I believe indicated that if I did not, I would indicate that. I'll tell you what. Why don't we just confirm the list? I'll just take care of it.
Yeah, I would appreciate
Okay.
that.
Yes, of course.
If there should be in a Word document, and I think it's pretty easy to be done, and we appreciate it very much.
Yes, fair enough.
With that, I think we're done. Is there anything else that we need to do today?
Mr. Hearing Officer.
Well, then, thank you all very much, and I hope that if and when we see each other again, it won't be remotely. This has been a little difficult, and but we're all hopefully out of the COVID tunnel. And let's hope there's no tunnel around the corner. Thank you, and have a good rest of your day, everyone.
Thank you.
Thanks very much.
You all.